books and case laws are coming, but due to talk of the Tikia Para, has not yet come. Not today only.
You are for the?
I am for the petitioner.
No, I am appearing for the state response. Not
No opportunity.
Yes.
Fine.
My lord, may I be permitted to
Not today, my
mention
lord. Or
for
next
inclusion of,
application.
for inclusion of a review petition which appear number
Give,
of times, and let it be in the next week, my lord. It is
It will come in the monthly list.
I'm seeking a lordship's kind.
very urgent, my lord.
Review is very urgent.
Review application.
I'm seeking a lordship's kind leave to file an appeal without the certified copy, my lord. File an appeal without the certified copy.
Date of order?
My lord, on 10th of February 2026, my lord. This
Give
order was
the,
passed by Justice Bhattacharya.
give the usual undertaking. You give the usual undertaking.
As the lordship is absent.
May I permit to mention for increasing the list, my lord.
Hmm?
Increasing the list, my lord.
Number one.
What the respondent?
This matter relates with compassionate appointment matter. The petitioner is the daughter of a government employee. He was working in the health department and he expired on 25/5/2006, leaving behind his unmarried daughter and wife. Then what has happened, my lord? Both the daughter and the wife applied for compassionate appointment on 22/1/2007. Then, my lord, Chief Medical Officer, being satisfied, recommended his name on 19/2/2010 and forwarded to the Joint Secretary Health Department. But Joint Secretary Health Department has not considered. Since then, it is being kept pending. I filed an original application before the West Bengal State Administrative Tribunal, my lord. Tribunal has passed an order on 10/4/2019 that, and since then it is pending, my lord. Your lordship will find that order on My lord, if your lordship kindly come to page 31, my lord. This is the last order, page 31. And State Administrative Tribunal is not available, my lord. There is no judicial member over there, my lord. It's not functioning. As the related matter is pending before the Honorable Apex Court, let the matter be kept cenadine for the present and with liberty to mention after the outcome of the Honorable Apex Court, my lord. And what has happened in the meantime, Honorable Apex Court has decided the matter, my lord.
Which matter?
My lord, I'm placing those matter judgment before your lordship, my lord. Regarding compassionate appointment, my lord. My lord, 2025, volume 5, page 712. Volume 7. 2025, volume 5, page 712. My lord, paragraph 32 and 33, my lord. 32, 33 and paragraph 57.
Yes, we have seen this judgment. Yes, we have seen this judgment. Yes.
And page 57, my lord. Paragraph 57, my lord. Yes. May I read, my lord? The existence of a policy issued by the state government is a sine qua non for making appointment on compassionate basis. The appointment must follow the stipulations made in the policy. It is therefore no brainer that in the absence of a policy governing compassionate appointment to post under a local authority, no appointment could be made on such an authority and compassionate ground. But in the absence of any policy, compassionate appointment cannot be made. And your lordship will find the policy at page 68, my lord. It starts from page 57, 67, my lord. Okay. Page annexure P6, my lord, page 67. The scheme may be called West Bengal Scheme for Compassionate Appointment 2013. This will come into force with effect from the date of issue. Then application. This shall apply to a dependent family of a government employee who dies while in service. Then, my lord, many definitions were given. If your lordship kindly turn to the next page, my lord, unmarried daughter. Unmarried daughter who on date of death was incapacitated or unmarried wife.
This judgment, how you are saying this is what the tribunal was referring to in its order of 11/4/2019. This is not, you read 11/4/2000, a related matter is pending. How this is related to your case?
Because related means, my lord, regarding compassionate appointment, that matter has been settled by the Honorable Supreme Court, my lord.
No, it doesn't. It surely does not. What you're
The
trying to
Supreme
say
Court
does
says-
not make any sense.
But Supreme Court says that without policy,
It
nothing.
is not a related matter. That is a law. Everybody knows, even this tribunal knows, it has been not before, much before this judgment, this is the law. When it says related matter, it means related to your claim. So what is that related matter? This cannot be a related matter. There are judgments like this passed very frequently.
My
Every
matter,
now and then.
my matter relates with compassionate appointment.
No, it doesn't. There is something else. There has to be something else.
Yeah, no, my
Who is claiming the?
lord. Unmarried daughter is claiming for the appointment.
So therefore,
Unmarried
Page
daughter.
20, marriage took place in 2008.
no, that's not the
That
point.
lady is married daughter. Is not
See, before the tribunal, he has not
My lord,
raised
at the
any
time of
objection.
death,
He has not raised any objection that his matter is pending for disposal of a related matter.
related matter.
It is pending since April 2019. Today he says in 25 this judgment is passed, so now the
That
related
judgment
matter.
does not
How it
apply
can
here.
be?
That does not apply, it does not apply.
Does not make sense at all. It is some matter related to your case. Not the general law was not declared. It's not that there was no law on that day.
my lord,
Covering the field.
It is true, my lord. No specific order was passed by the Honorable Apex Court regarding my matter, my lord.
Not necessarily your matter, related matter.
Related means, my lord, regarding the
Related means
compassionate-
law on compassionate appointment. Till this judgment, there was no law on compassionate appointment. What are you submitting? That's why we are saying what you are saying does not make sense. Cannot be. What was the related matter? You are required to tell us because this is the order passed in your case. You have never challenged or objected to this order. This order is 6 years old. It was adjourned sine die. Which matter was pending? Where is your OA? Where is the affirmance made in the OA?
Original application. Original application. No. No.
We starts at page 37. Forty-nine. No.
So this grant of benefit to a daughter,
Yeah.
it has been in the scheme since when?
Scheme 2008. Then
It was incorporated in 2008.
8. But kindly see that lady married in 2008. She is not dependent upon her father.
That's not the point,
lord,
sir. We are trying to
At
ascertain
the
what
time
was the
of
matter.
death, at the
That
time
means
of death of father.
because she has made an application,
Hmm.
being unmarried daughter, if there was no provision prior to 2008, then perhaps that is the matter which was pending before the apex court, whether daughter can get an appointment or not. He's saying now Devabrata Tiwari is decided.
The theory is not
Huh?
applicable. The Bhopata theory does not apply here.
No, it has nothing to do. We don't know how he is submitting. It has nothing to do why he is submitting this judgment. We don't know.
Married daughters are entitled to get appointment on compassionate ground, my lord. I am referring one judgment before your lordship, my lord. Your lordship, kindly have a look. My lord, paragraph 113 and 116.
That is with regard to the school teachers, not to the state government.
There is a different EMP.
Yes, but there was aided school. No, that is a scheme. Most subject to correction.
No, but there is one judgment regarding unmarried daughter.
Yes, by special bench with regard to the application for appointment on compulsion ground in respect of aided schools, not this scheme. And can you see the judgment?
Oh, this is the judgment. This is not.
Judgment of Justice Dipankar Datta, sitting with Judge Nishita Matre.
Yes, this is the special bench.
Nishita Matre, Tapobrata Chakraborty and Dipankar Dutt.
With
Three
regard to
judges
the
bench, my lord.
appointment of compulsion ground in respect of aided school, not government labor department.
There must be some case pending regarding the government service also. That is what the tribunal has recorded
Yeah, but,
in 2019.
yes.
But
He is
no
trying
reference-
Devabrata
no
Tiwari
reference
judgment.
was
What are you
given.
doing, sir?
But no reference was given in the order, my lord, for that, so we can find out.
You are the applicant. It is not that you are a stranger. You should be knowing. It is an order passed in your case. No reference was given, so you don't know what has happened in your case. You are not respondent. Kind of submission you are making.
And which matter he has not been?
There must be some matter
Some
pending
matter.
for considering whether the married daughter can have a government employment or not. And why you have applied in 2017 after 9 years, 10 years, 11 years.
My lord, I was waiting, my lord. I went to the office of the joint director. They said, yes, he will give you one appointment. But that's why I'm just running from pillar to post, my lord. After that, I compelled to file one original application before the state tribunal, my
How
lord.
many times you ran from the pillar to the post? Show us in between 6 to 2017.
My lord.
How many times you ran? Show us.
Well, it is not stated.
There
but
is nothing, sir. That is why we are saying.
I've not
You-
stated. but
Today you can
true-
say ran from
but
pillar
true
to
fact
post.
is that, my lord, I went to the office. They assured that yes, appointment will be given. But after that,
After that,
at
you
the end
slept
of
for
the
a
show,
decade.
when I
All of a sudden, you awoke after a decade. That where is my appointment?
my lord, it's true that it's late.
Nothing.
But after that, I came
And this
before the
judgment,
tribunal, my lord.
the judgment that you are citing deals with this situation. Whether at any time you can come to the court. You
Okay,
come to
no.
this judgment, you see.
Now
it
she is
says-
married. Now she is married. She is
That
not
is
Now,
immaterial.
now he is married, my lord.
Even
He
if she
cannot
was
remain
eligible.
unmarried for decades.
Even if she was eligible, after 11 years, can she invoke the court's jurisdiction for this?
But if the matter was pending in 2019, 20 could have mentioned before this honorable court or before the tribunal, 21, 24, 23.
Well, tribunal is not functioning now.
No,
my
no,
lord.
2019.
Today it has become urgent after 7 years. After remaining sine die for 7 years, it became urgent all of a sudden. First you move after a decade, then you keep it there for 6 years, and then when the tribunal is absent, it becomes urgent.
My lord, the learned advocate who appeared in the tribunal, my lord, they said that yes, honorable
You
judge
rely
will
on
come very
everyone.
soon.
You are too
Honorable judge will come
kind
very
to
soon.
everyone.
Was
First you
waiting.
rely on the authorities for 1 decade. Then you rely on the lawyer for 7 years. Then all of a sudden, you become very wise. Just see the pattern. How can you claim a compassionate appointment? In view of this judgment, you cannot. This judgment is the judgment which says that such person cannot be permitted to invoke the court's jurisdiction for such benefit after such a delay. Inordinate, long and inordinate delay. This is clear in your case.
But now the scheme has come, my lord.
Oh, before this judgment scheme was not there. What are you submitting, sir?
Scheme was there. Scheme was there. No, scheme was
Since 2008, there is a scheme. Now a scheme has come.
there. Your Lordship kindly consider.
We don't think that you are entitled to any appointment. Which paragraph? Where is the paragraph in Devabrata Tiwari? We have seen this judgment.
দেবব্রত theory-টা দাও তো।
কোনটা? এটা বলছো?
দেবব্রত theory-টা।
দেবব্রত তিওয়ারি দিচ্ছি। এই যেখানে আছে।
মানে local bodies, there was no scheme.
No, that's not the point. There is a issue of delay here also. The concept of immediacy was considered in Devabrata Tiwari. That compassionate appointment hinges on the concept of immediacy. Which paragraph? That is what we are looking for. Not after 15, 16.
Paragraph
30?
33.
Yes. Thus, there is a compelling need to act with a sense of immediacy in matters. This is that paragraph.
But I have applied within a year, my lord.
You should have. Why did you rush to the tribunal after 11 years? You should have waited for some more time.
There's a poor person, my lord,
Yes.
Group D employee. His father was a Group D employee.
Therefore, there was no rush. He could have waited for some more time.
No. But I have applied within time. That is the primary demand of compassionate appointment.
There's nothing, sir. Nothing can be done. Take note. You heard the learned advocate for the writ petitioner and the learned state advocate, learned AGP appearing for the state. The short facts leading to filing of the application before the West Bengal Administrative Tribunal within bracket SAT for short is that the petitioner's father died while in harness.
But two,
I don't know, two, I am for the state led by Mr. Learned GP Lordship. He was there, but
but in this matter, the issue relates to being a medical official. The petitioner here got for no objection certificate from the Health Department of West Bengal to participate in the selection process conducted by AIMS Kollan. And instead of submitting representation reminder and legal notice, no whispering has come from the end of the authority, state authority. Therefore, preferred an original application. Preferred an original application before the tribunal. But since though no bench is there, therefore the matter refixed on 25th.
When did you apply for the NOC?
Minor.
When did you apply for the
Minor.
NOC?
That I applied on 3rd November 2025, page 89, my first application.
Page?
89. 89. Not
No, they are not. They are seeking NOC from the state.
no. Not answerable.
Any communication thereafter?
My lord, page 90. From the end of the authority, no mind.
actually the petitioner has not completed the 5 years, whether he has mentioned it in the averment also paragraph 5. Regarding this aspect, he have few months left for having 5 years and getting
No, only 15 days. On 2nd
no, on March.
2nd March 2026, 5 years will
I uttered that few
Which
Lordship, paragraph 5 he has mentioned.
please let him, yes.
Paragraph 5 he has mentioned that he has not completed 5 years. Regarding that aspect, Lordship, we have asked for the instruction.
So there is any rule that says before 5 years he can.
Lordship, there is. It has been mentioned in paragraph 5 by the petitioners only.
Paragraph 5 of the
Paragraph
writ petition.
of the application, Lordship.
in the writ petition and original application. Paragraph 5, page 5.
No, where is it in the OA? Show us from the OA. Show us this averment in the OA.
Page 30. Page 30.
2016 there is a notification. Paragraph. Page 30.
To start from page 29, para 1B.
Page কত বলুন না?
29, Roman 4.
No, there is a bar to applying for NOC or he has to serve for 5 years minimum.
Sub 5 years.
Lordship, he can apply, but before 5 years there is a bar, Lordship. Regarding that aspect, Lordship,
You are repeatedly using the word bar. We
Lordship,
are asking you bar in making an application for NOC or bar in leaving the service before 5 years.
no application he have to make after 5 years.
Where is that provision? Show us.
For that reason, I have asked for instruction from the department.
So you don't know and you are submitting.
Lordship, it has been mentioned in the
Where has he said that there is a bar to application
right now I
before
am
5 years?
accompanied with the same Lordship.
No, where he has said, what is the basis of your submission?
Lordship, he has mentioned in the paragraph only.
Yes.
In the averments.
That there is a mention that there is a bar on making application for NOC.
No, he is undertaking that he will
Sir, we have asked you
Lordship.
thrice whether there is
Only
bar
time-
in making application for NOC or there is bar in leaving the service before 5 years. You say in making application. Where you are saying this?
That aspect, Lordship, kindly allow me for a accommodation
You
to
don't
take the
know,
instruction.
then why do you submit such things of fact?
Lordship, regarding that aspect, Lordship, whether 5 years he can apply within before 5 years or he can leave the job, that aspect, Lordship, I need to take instruction.
Then why you are submitting that he cannot apply?
Lordship, he has mentioned in the
Where is he mentioned? You are running in circles unnecessarily. This is not expected that you will make something which is submission which is not there on the record. He has said that he will not leave before 5 years. That
Lordship,
is
he
what
has
he has
given
said.
undertaking
So
that
what
he
is
will not
wrong in that stand?
kindly accommodate for
Because he has hardly some days to,
some days to complete.
yes, you take instruction.
Kindly
in the-
accommodate me for
The learned advocate for the writ petitioner submits that this list.
next Tuesday. Grateful, Lord.
Why issue the NOC? You have done it in all the cases. Do it.
Grateful.
Not affidavit also.
Affidavit of- No, sir. On fact, we don't appreciate something being said which is not there on record. Please don't make such submission. Yes.
Item number 3 and 4.
Lordship, I am for the petitioner, Lordship.
We are filed the review application, but I'm being led by Mr. Kushal Chatterjee, but all of a sudden I was informed by his clerk that he has fell down in his residence all of a sudden and he fell sick. So
Something happening today which can it wait? We are informed by Mr. So and so, the learned advocate, that
Item number 6.
Today is the turn of Mr. Mukherjee to answer to my lord's call. Whether the judgment that has been passed by your lordship, whether it has been complied with or not by the state.
what is your instruction, Mr. Mukherjee? Whether that case Arjun, what is the name of that matter?
Arjun.
Arjun Kumar Soren.
Benefit has been extended to the petitioner therein, or it
In that Arjun Kumar Soren, initially mother was considered. Mother was found to eligible. Before giving appointment, mother detected cancer, she died. Then the application should be directed to be transferred. Mother held that this is not a transfer, it is a fresh application. That's why the application has been allowed.
please respond to our query.
Mother?
please respond to our query, what we have made in the last order.
Oh, so far as this judgment is concerned, government is considering the judgment and pending consideration before the Honorable Court to comply the order or have an opinion from the LR.
Obtain opinion.
Before going to the SLP or to a opinion
What
of
is the
the
date of that judgment?
26th of August 2025.
But we are considering this judgment. Government is,
It has not been implemented.
as per my last information we have got, that government is considering.
Considering is a different aspect.
Considering to implement the order.
So where is that stand? We asked you to place that stand on record.
Day after tomorrow, but I'll detail.
You come tomorrow. Why day after tomorrow? If you have already, if they have informed you, we will give it on record tomorrow. We'll see. Not today.
Item number 7.
7 my lord, I am for the petitioner. My lord.
The 7 eventually, my lord, I have got my instruction. My lord, Lordship, kindly give me 1 week time and I shall find my affidavit. Eventually, yesterday night, but I have got instruction.
2010 WPST.
Yes. Cause of action arose in 2001. Then 2009-10, my lord, charge sheet was issued. So, my lord, the delayed initiation of proceeding was challenged. There was a stay of all further proceeding.
So as of today, there is a stay.
There is a stay.
As prayed by learned AAG, for filing affidavit.
Item number 8.
Whether this maximum age criteria, we have passed a judgment recently.
So far as relaxation, my fancy, age 42 is two deficiency. One, educational qualification, he must be up to the age standard, and what about age relaxation in exceptional cases.
Age relaxation in exceptional cases. Educational qualification relaxation in eligible cases.
Eligible.
So who is eligible?
That's it, that it is decided by the finance department.
So it is in the hands of the authority to take a decision. There is no guideline. There is no. It is uncanalized power. So in any particular case, if the secretary wants, he can appoint someone even if he is second standard pass or illiterate.
Paragraph 6 small b
Of?
of 2013.
Yes, read it.
Relaxation in education courses may be granted in eligible.
Ineligible case means what? Total arbitrary discretion in the hand of the authority, or any guideline, SOP, any kind of rule, regulation in this regard has been framed by the authority. We asked you on the last day itself. We have framed that issue. When you say ineligible case, then if the secretary wants, he can say he is not eligible. And if the secretary wants, he can say he is eligible. So is there any guideline, anything circumscribing his exercise of discretion, or it is totally upon him to decide the issue? Then in appropriate case, he may allow someone who is illiterate also to, maybe, we don't know.
No, Honor, according to the rules, Honor, he must have not more than 40 years.
See, relaxation will only come if he does not fulfill the rules.
Condition.
So therefore, why to rely on the rule? Rule says 8 pass, everybody knows, he also knows. So it is to be, if it is to be relaxed, then to what extent, and in who will be an eligible person? Does this scheme vest unlimited discretion in the administrative authority?
That cannot be.
We don't know. Therefore, we asked you, where is the...
Well, kindly adjourn for a week because the officer concerned has transferred for me.
Because this issue is arising in so many cases, might as well we should decide it. See what happens. A question has been framed in the earlier order dated 20.
There is nothing. There is nothing. Guideline.
Item number 9.
Then we will say, you take him there. And we must take. Means eligible means only that whether it is indicated. There is no specific reason circumscribing the exercise of discretion for educational purposes. Then eligibility will mean report of the 3-man committee. If they say that the family is not, then he will become.
Yes. My lord, M for the petitioner, my lord. M led by Mr. Satvik Bhattacharya, my lord.
Where is this is arising out of tribunal's order?
Yes, my lord.
Where is the tribunal's order?
My lord, at page number 107 of the paper book, my lord.
Not, sir. 107 is not the tribunal, sir.
In May 2024.
107.
Yes, my lord.
102, 102.
Yes, 10. The first wife was granted any benefit? You are claiming to be the first wife. Obviously, you are claiming to be the first, right? We have understood. Yes. So, but we are asking whether you claimed any compassionate appointment also
Yes, there has been a claim for compassionate appointment done
by you.
Yes.
What happened on that?
Nothing has been.
Because pendency of the
Hmm?
because pendency of proceeding between the two wives.
So, if it is not, if her proceeding is over, then she will be.
Our case will be considered.
Where do we find this stand?
That was not discussed.
No, because you are resisting her claim on the ground that she is a second wife and the marriage is solemnized during subsistence of the first marriage.
As soon as this issue is resolved by the government court, certainly her case will be considered by the government immediately.
Have you made any? Yes. What steps you have taken regarding your compassionate appointment claim?
We have made a representation for getting the compassionate appointment, but no response.
What is the date of demise of the government servant?
On 4th October 2021.
And he died from which post?
My lord, he was a constable at STF, my lord, STF Kolkata Police.
Not surviving. Yes.
My lord, in their affidavit in opposition submitted by the state as well as the private respondent, my lord, they have not disclosed any document regarding the claim of the first wife, my lord. They have only showed the rules. They have only stated, my lord, at page number 290 of the volume 2 of the paper book, my lord. At point number 3, my lord, no proper permission under the relevant slash service conduct rules was obtained for contracting second marriage. Stop. Therefore, the second marriage is void under Rule 30 of the West Bengal Government Servants Conduct Rules 1959. Hence, the alleged second marriage is void in law for all service related benefits. My lord, we are not claiming compassionate appointment for the second wife, my lord. We are claiming it, we are demanding it for the second paramount interest of the two minor child who are dependent sons of the deceased employee, my lord.
They have been given a proportionate share in the family pension.
No, my lord. We have been.
So that has been given. Hmm?
My lord, there is a handwritten letter of the deceased employee, my lord, at annexed P12, my lord. At page number 104 of the volume 1 of the paper book, my lord. This is the handwritten letter. The typed copy as well as the translated copy has also been annexed in the paper book, my lord. The translated copy is at page number 110, my lord.
Yes.
My lord, here the deceased employee has stated all the facts after his marriage with his first wife, which is the private respondent, my lord. May I read, my lord? May I read, my lord? I, Shri Shubhendu Mondol, son of Bimalendu Mondol, village Bahirchok, police station, Pathor Protima, Dolahat, district South Chobbish Pargona.
He is no longer alive.
Yes, my lord.
So therefore, there is no point in reading that.
My lord, this handwritten.
The point is under which provision you will get the appointment. Just show us. Forget about what he has written.
My lord.
You show us your claim is forcible by which provision? Please show us.
Judgment. My lord, kindly come to page number 34 of the volume 1 of the paper book.
Yes, what does it?
In point number C, my lord, we have stated that in the context of a compassionate appointment policy, the focus is on mitigating the.
We are asking you again. There is no point in reading what is your perception, what you think is compassionate appointment. You can interpret something which is there in a policy. What is the provision in the policy? We are asking. Which provision is there in the policy based on which you can stake a claim? Please show us. There cannot be, because the service rule does not acknowledge the legitimacy of a second marriage for any purpose. So therefore, there cannot be any provision. So how you can get the compassionate appointment? What is wrong with the tribunal's order?
My lord, as far as, my lord,
Yes, you are a parent.
My lord, it is admitted position that the second wife has no right to get appointment on compassionate appointment if during pendency of the first marriage. But here in this case, my lord, your lordship kindly consider the dependency and the immediate need are, and my lord, compassionate appointment has been paid for on behalf of the minor child of the deceased employee.
That is nothing unique. In every second marriage, this will happen.
Minor child,
There is nothing unique about, you are trying to make out as if it is something unique. This is in every second marriage, they will have offspring. They are given share in the group insurance and all these dues. That is the rule.
No, it is not the second marriage. Question is, my lord.
Then you have to get a declaration, then only. That is a possibility. Maybe. Then you get a declaration, you raise your claim. No, who is stopping you?
But this honorable court, while considering the natural justice under Article 14, can my lord decide, my lord, whether
it is a first marriage or second marriage.
No, I am not questioning the first marriage and second marriage. Then I am questioning the dependency of the minor child.
We are
of the
not on
deceased
that.
employee.
We accept that they are dependent. You need not say anything.
And my lord, they are
We accept it. Then
they are in
what is
immediate
to be
need,
done?
my lord. I am referring the judgment passed by this honorable court, my lord, in larger bench.
Yes.
Where the, my lord, this court, where it has been directed that the dependency is to be proved. Dependency is to be decided fast. But your lordship, kindly have a look.
We are not on that. Please don't try to make such submissions which have no application to your facts. Your fact is an admitted position that you are a second wife. Your fact is an admitted position that there is entry in the service records regarding the first wife. There is no dispute that whatever could have been apportioned has been apportioned for the sustenance of your children. Whatever the rule does not permit has not been given. Then in how the writ court will direct them that contrary to the rule you give them some. We are asking you that.
Yes, my lord. Your lordship, kindly have a look at copy.
That is not relevant what you are trying to show, that dependency has to be proved. Who is saying, who is disputing that they are not? If they were disputing, you would not have got any portion in anything.
Well, it is a larger bench decision of this honorable court.
Larger bench deciding something relevant, not everything.
That is
yes.
Well, that compassionate appointment is not a regular source of recruitment. That it is an exception to the general rule of recruitment and cannot be claimed as a matter of right. That it is not a heritable property and that a claim for compassionate appointment has to be considered confined to whatever is provided for in the relevant scheme and not
correct. So therefore we are saying that
propositions of law.
Yes.
Which
As
are
per the
well
scheme.
settled. We therefore do not propose to separately refer to all such decisions cited by the parties that lay down the law noted above and burden this judgment unnecessarily. However, bearing in mind this well-settled principle of law, there seems to be room for doubt on a couple of aspects which need to be cleared. First, although appointment on compassionate grounds can only be made following the laid down policy, a given case may require examination of the point as to whether an employer has unfettered, unbridled, and uncontrolled authority in specify who shall be eligible for compassionate appointment.
That is not an issue arising in your case.
Well, putting it differently, can the employer be given a free hand and allowed to act arbitrarily and specify a particular case of persons as entitled to apply for compassionate appointment? If the action of the employee is found to be arbitrary on a challenge being laid, is the court powerless to strike down the specification? None is above the Constitution, and therefore decision based on whim and caprice have no place in the system. And therefore decision based on whims and caprice have to place in the system since in the fast expanding measure of judicial control over administrative action affecting rights of citizens is amenable to challenge. We are of the view that the questions posed in this paragraph cannot be answered in the negative. So answer the possibility of an appointment being directed upon striking down the policy cannot be ruled out. We would therefore read the statement of law that appointment beyond the policy cannot be made applies in case where the policy or the relevant scheme is not under challenge. If the policy or the relevant scheme is challenged, and the court finds merit in such challenge, different considerations are bound to arise, and it is for the court to pass such order that would be warranted on facts and in circumstances. Secondly, we may at this stage record having noticed a divergence of opinion of the Supreme Court on one point. The Supreme Court in paragraph 5 of the decision in we read it as laying down the law that an application for compulsory government ought to be considered in the light of the policy in vague. When such application was made, however, the subsequent decision in Rajkumar, without noticing Abhishek Kumar, appears to have taken a view that is apparently inconsistent and the two views cannot be reconciled. It has laid down the law that if during the pendency of an application for compassionate appointment, the relevant scheme is substituted by a new scheme, the application has to be considered in terms of the new scheme and not the scheme that has become extinct.
You are reading judgments which have no application in your case. We don't know why you are reading it.
Kindly have a look at paragraph 71.
You have just read it. We have heard it. We don't know how that applies.
Paragraph 71, my lord.
How it applies to your case. That is the point.
But my
You
candidate,
may read any judgment. It has to be relevant.
my candidate,
Irrelevant judgment does not.
as per this judgment, my lord, my candidature could be considered by this honorable court.
We don't know how you are saying that.
But I'm
Please try to make out a case based on the law as it is. You cannot just read anything in court and say that apply this to my case. Cannot be. You know better.
But let me satisfy my lord. Only
The judgment you have read in all the paragraphs must have said 10 times that it has to be in accordance with the rule. It cannot be contrary to the.
71, my lord. I'm free. Conditions which are inevitably required to be
Required to be.
which are inevitably required to be fulfilled by an applicant for appointment on compulsory ground, paragraph 71. In terms of a scheme framed in the legal are threefold. Number one, the immediate need for an appointment. Number two, identification as dependent and satisfaction in relation to dependency. And number three, possessing required qualification. The first condition, that is immediate need, has to be of paramount consideration for an employer while it proceeds to consider a claim for compulsory appointment. Such need might arise out of a death of an employee or even physical incapacitations of an employee, rendering him disabled to continue service. In either case, it has
Sir,
to be
again and again we are asking you, person who is ineligible under the rule, whether he can be considered. How that applies? That is to see whether the person who is otherwise eligible, he can be given or denied. This is how a second wife can be given a compassionate appointment.
the minor children,
Unnecessarily you are reading
the
those.
minor children are eligible.
Yes, so minor children should be appointed.
Well, on
What are you saying?
my lord, mother of the minor children has paid for compulsory appointment for the paramount consideration of the minor children.
There, what is
That
that?
is to be considered. by
What is unique, sir? They say every second marriage this will happen. And you know that the service rule bars. You have not challenged the service rule. You have not challenged the scheme. You have entered into a marriage knowing that he was earlier married. You admit to the first marriage. How you can get? Reading that is, you are reading something which is wholly irrelevant to the case, whatever you are reading.
If the minor,
That you give it, we'll consider. If that is all you want to argue, give us.
I am reading
Yes.
on two lines.
Don't read again. We have heard enough.
In either case, it has to be established that paragraph 71. In either case, it has to be established that unexpectedly the family of the concerned government employee has been put to extreme financial distress, so much so that but an appointment of a dependent on compassionate ground, the family members of the deceased employee may not survive. It is therefore the need for immediate relief to mitigate the hardship. Paragraph 71, my lord, I am reading. Relief to mitigate the hardship arising out of sudden death of the breadwinner.
This is the special bench judgment regarding daughters. It is not that we have not seen this judgment. We have seen this judgment. This is regarding our married daughter under the school service. We have seen it. Therefore, we are asking how it applies to your case. Unnecessarily, you are reading this judgment.
Minor children.
Yes, this we know what you are arguing, but we don't see why you are arguing with this judgment. That is what we are trying to understand. How this applies to your case. You can read any judgment.
But I am
It has to be relevant to the case.
Not for second wife.
This is not a case of a daughter, whether a daughter can be discriminated by virtue of the gender. That is the only issue arising here. It is not that an ineligible person will become eligible in an appropriate case. Cannot be. Anyway, any other judgment, then you give it. We'll see.
My lord, in Mukesh Kumar, my lord, Mukesh Kumar and another versus, my lord, the Supreme Court, the 2022 Supreme Court 163. But in this, it has been dissent, my lord, held, my lord, dissent cannot be a ground for denying employment under scheme of compassionate appointment. Dissent cannot be a ground.
Dissent.
Dissent cannot be a ground for denying. Here, my lord, this.
Who is dissenting? What is the dissenting here?
For denying employment, that is the second wife, second marriage.
Any judgment you will cite. Having no application to your case.
Well, dissent not to be understood to encompass familial or.
Here is the question of dissent, sir. Where is the question of dissent? Where is the question of dissent? It is a rule whether the rule permits or not. If the rule does not permit, whether it can be given. Why you are arguing these things, irrelevant things?
If my right, my lord, on Article 14.
All right, give it. We'll consider that also. That's all.
Well, the case of Tripathi has also been.
Huh?
The case of VR Tripathi has also been. Case of VR Tripathi has also been distinguished.
Can't understand what you are saying.
Case of Tripathi. But you also in this case, my lord, in this judgment, the my lord, it has been noted, my lord, where the government servant is survived by more than one widow, the family pension shall be paid to them in equal share. On the death of a widow, her share of the pension shall become payable to her eligible minor children. If at the time of her death a widow leaves no eligible minor child, the payment of her share of the pension shall cease. Your lordship kindly consider the dependency and whether immediate need of the two minor child.
Based on sympathy, a relief cannot be granted. We expect that you know that.
But the children are the eligible.
We expect that you know that. You are repeatedly saying need of the children. Based on sympathy, a relief will not be granted. It will only be granted if there is a law permitting the grant. You are not showing anything, repeatedly saying they are dependent, they are minor.
Kindly consider the object.
There are thousands like you. What can be done? It has to be done. See, everything has to be done within the limited means of the government. And that is how the schemes are framed. That is how the best benefit is achieved. If the scheme is flawed, you are required to challenge the scheme. If not, then where is the scope of looking into these things?
But the scheme family put family. Well, your lordship, the scheme as placed by my learned friend from the state, well, family includes the following relatives of government subject, namely for the purpose of a death gratuity, wife in a case of a male officer, sons including stepsons, and for the purpose of a family pension, minor sons including adopted sons are entitled, my lord. First of all, my lord, family pension, my lord, petitioners number 2 and 3 are very much entitled to get 50% of the family pension. That is, my lord, they have admitted, and it is admitted law, my lord, as per the definition of the family. My lord, two children of the deceased employee from the wedlock of the second marriage, second wife, well, they are too much entitled to get family pension. So far compassionate appointment is concerned. Paragraph 8 is too much relevant. But paragraph 9 also, my lord. কোথায় আছে হ্যান্ডরাইটিংটা কোথায় আছে? কপি কোথায় আছে?
Yes, paragraph 8 and the earlier judgment, which paragraph? 70?
71.
Yes, we have seen.
Yes, my lord. Now, may your lordship kindly come to page 24 of my paper book, first volume. But here I have stated that provision of Rule 104A of the West Bengal Service Rules, wherein was specifically mentioned that any children born out of the second marriage shall be legitimate. And as such children are assented as members of the family, legal heirs within the meaning of Rule 7(1), Subrule 1, Clause E, Subclause 1 and 2 of the said rule. Paragraph 14, paper book, page 24, first volume.
Yes.
And my lord, wherein, my lord, it has also been stated that as the petitioners were spending their days in extreme financial stringencies and at the mercy of their maternal uncle, who has a little social, it was also mentioned in the said representation that the petitioner number 1 is failing to provide proper treatment to his minor son, namely Songit Mondol, due to the non-dispersal of the legitimate pensionary benefits of the said deceased Subendu Mondol. And now your lordship kindly come to the page 26,
Yes.
paragraph 17, that the petitioner number 1, that is the mother's second wife, has got only 50% of the group insurance and gratuity amounting in total rupees 4,60,410 as the natural guardian of the two minor sons, and was denied to get any sum on account of Provident Fund, General Provident Fund, area family pension, and other pensionary benefits of her said deceased husband Subendu Mondol by the respondent with the region based. So, my lord, only a portion of 50% amount for group insurance and gratuity has been paid only. And no PF, no PF, no GPF, no area family pension, but it has been provided to the petitioner number 2 and 3, being the legitimate children of the deceased employee, which they are too much entitled to get such.
Under which provision?
Well, Rule 104A and the Rule 7(1)(e)(1) of and 2 of the said rules.
Please place 104(1)(4)A. Where is that?
Hmm? 104A, if This is the rule 1971. If the son or daughter of a government servant is suffering from any disorder or disability of mind, or is physically crippled or disabled so as to render him or her unable to earn a living even after attaining the age of 18 years. In the case of the son and 20 years of the daughter, the family pension shall be payable to such son or daughter for life, subject to the following conditions. The rule 7, what?
Where is this rule? Which rule you are reading?
My lord, the West Bengal Service Death Retirement Benefit Rules
DCRB.
1971. রুলটা করি সেভেনটা কোথায় Pastoral law se come to rule 7. Rule 7 definition clause family clause E family. Clause 3 of clause 1 of clause E of section rule 7. Sons family includes the following relatives of government servant, namely for the purpose of a death gratuity, sons including stepsons. Clause 3. Petitioner number 2 and 3.
Which rule you are reading?
Rule 7. Definition clause.
Yes.
Clause E family, subclause 1, clause 3. For the purpose of a death gratuity, sons including stepsons are entitled to get. Now, my lord, clause 2. For the purpose of a family pension. Subclause 3. Minor sons including adopted sons.
Rule 7, 2.
Rule 7. Clause E family.
Yes.
Next, my lord, 1 for the purpose of death gratuity. Next, clause 3, sons including stepsons.
Yes.
This is for the death gratuity. And my lord, next, my lord, sub-rule 2 for the purpose of a family pension. Clause 3, minor sons including adopted sons. Now, my lord, rule 104. 104A. Before 104A, one note, my lord. Where a government servant is survived by more than one widow, where if government servant is survived by more than one widow, the family pension shall be paid to them in equal shares. On the death of a widow, her share of the pension shall become payable to her eligible minor children. If at the time of her death, the widow leaves no eligible minor child, the payment of her share of the pension shall cease.
This you are reading which provision?
Rule 104A, just before Rule 104A.
104A you have just placed.
100 before,
Before 104A.
just 2 paragraphs before. Note.
After A and B, after A and B.
After A and B. No, no, eight. Your Lordship found it. But this note has been amended on 13th January 1997. Normally, your Lordship kindly come to 104A. If 104A, if the son or daughter of a government servant is suffering from any disorder or disability of mind, or is physically crippled or disabled so as to render him or her unable to earn a living even after attaining the age of 18 years in the case of the son and 21 years in the case of legitimate, the family pension shall be payable to such son or daughter for life, subject to the following conditions. However, under section 17 of the Hindu Marriage Act, a second marriage solemnized during the lifetime of the first wife is void. Such second wife is not entitled to receive any benefit due to on death of a government employee while in service or after retirement. Now, however, under section 16 subsection 1 of the Hindu Marriage Act 1955, though the second marriage is null and void, any children born out of such second marriage shall be legitimate.
Which provision are you reading?
Rule 104A.
Yes. Yes, that you have already read. Why you are again reading?
That is done a compiler's note, my lord.
No, that you have already read. 104A you have already read. You need not read again.
So, my lord, petitioner number 2 and 3 are too much entitled to get family pension. 50%, at least 50% family pension.
And the remaining benefits. We
Huh?
will hear you.
And
Yes. We will hear him after we come back. There's one more aspect for you to also answer. Your husband has solemnized the second marriage and there is children. They are required to be maintained. But regarding compassionate appointment, we are not asking about it. We are only asking you about the maintenance.
But whatever share they were required to be given as per law, that has been disbursed, as I am told here. Now, the thing is this, the balance which is remaining, that is family pension. Now, on the family pension, who would be entitled, rule is very clear. That has also been clarified subsequently. Whatever has been shown to your lordship, that has been clearly clarified in subsequent days. Now, it is very much clear, rather explicit, from the clarification that second wife is not entitled to family pension. This is number one. Number two
has been clarified.
Yes. And number two, the children out of the second marriage are also not entitled to. That has been very well clarified. This is why. Kindly similar. This is memorandum dated 12th November 1997. 12th November 1997.
So this is after this note of 104.
Yes, yes, yes.
That is of 91.
71. 71. That is of 71. Death cum retirement benefit rules.
No,
And
no,
this is of 1997.
That note has been added when?
13 January 97.
97.
Right. This is also of 97. Subsequently. Finally, the last paragraph. As long as the legally wedded wife is.
So that we have see.
This is number one.
Yeah, we accept even if we accept this.
Yes.
Is to be taken by the first wife. That does not mean that the first wife will not maintain those children.
Now, regarding children,
because
I understand.
Because it says if the first wife is not there, then everyone will get.
Right.
So therefore, whether the first wife is taking care, what she is doing, what she is not doing. If she was taking care, would they be here before the court? They may not have come if she was taking care.
What is not troubling your lordship? I fully appreciate. Now, if your lordship kindly sees this, with regard to the children, out of this is with regard to the second wife. Children I have handed up. This is with regard to the second wife. This is dated 4th August 1983.
Even later.
Yes. Left hand side. 4th August 1983.
So therefore we have not asked you about the second wife. We are saying if even these provisions which you are relying upon, if it is still in vogue, then there is a right of the children, but that is only a secondary right. The primary right is of the first wife. The secondary right means that they have right to maintenance from that amount, whether it is earlier through the first wife. If first wife is not there, then they will get in their own hands. So are you discharging your obligation knowing that they have the secondary right to this amount which you are getting? If God forbid something happens to you today, they will start getting.
I understand, but the secondary right, subject to your lordship's kind consideration and appreciation, secondary right when it comes, whenever I would be absent.
Correct.
So long I am.
Why? Only after your absence? Why only after your absence? Because as long as you are there, it is expected that they need not exercise their secondary right. Through you, they will get it. Otherwise, it is not independent of the first right. It is a sequel to the first right.
But the thing is this, not they are not residing with me. They are not residing.
Those issues you may raise only if you are bona fide ready to discharge your liability. If that is there, then issue arises. Please listen to us first. If that is there, that yes, whatever I can do after maintaining myself, after maintaining my own children,
Yes.
or after maintaining myself and maintaining all the children in equal way, there will be limitations that we understand. They will not get anything they want. No child can get. Even if you have two child from your first wedlock, neither one child can get everything. So it has to be a portion so that they all are somehow their life is sustained.
I understand, Lord. I appreciate also.
So-
Your lordship directs, Lord, if your lordship directs, definitely, Lord.
No, that we can direct. But the point is, we want to know your stand.
Problem is this, Lord, even if I take instruction from my client and she, Lord, promises that I will maintain, Lord, that may not be fruitful at a time. But if your lordship directs,
No, that we will decide.
yes,
If she comes with a positive view, we will decide how it is to be done so that nobody suffers a disadvantage. That we will ensure, but provided she is willing. If she is not willing, then we may or we may not, we don't know, subject to what the state says, what are the other provisions, whether a direction can be issued, not. We don't know today, we have not decided. Looking at the provisions, the way you have said, we find that they have a right, contingent right, dependent on your absence. So the whole object is only rational way of looking at it is that as long as you are there, they need not exercise this right. So taking this in,
not or cannot, Lord.
huh?
Cannot. Not-
Cannot.
Yes.
That's why, because they need not. That is the only rational way. Otherwise, why?
Lord, this is a conflict, Lord. So far, I understand.
No, why? Why? Because just listen to us. There is another aspect. Not only them, your children also cannot exercise that right as long as you are alive.
Yes,
So they are all at par.
absolutely, Lord. Absolutely.
Correct. So if they are all at par, that means you should treat them at par. That is expected from the rule making authority. So are you willing to treat them at par or you are not willing to treat them at par? This we want you to either tell us or you can sit together and decide. Your client is here.
No, Lord, she is not present in court.
If you can express the prima facie view of the court, then ask her to sit with them. If you can work out that, look, this is the maximum I can spare to take care of these two persons, subject to fulfillment of my expenses, then we can think of passing appropriate order. If not, we will have to decide the matter. In one case, we have undertaken this exercise. Mr. Mukherjee was there. I think no, there was another state council. In that case, they had come back and we just passed the order to apportion in terms of their settlement, which is being done by the authorities. They said we cannot issue two PPOs. We said we are directing. We directed that you issue the money in this way and it is being done.
Case of Purulia.
Oh, you were there, yes.
Because there is some settlement between the parties.
Correct. So make an exercise.
But only pension is only one.
Correct. We have understood. No, he is relying on certain provisions, saying that the law has swayed in the favor of grant to the second wife. Also, he says no, it has come back recognizing provisions that as long as the first wife is alive, only she will get.
And that has been clarified by the government in Proviso, Rule 104 Proviso. Why the disease government servant or pension is covered by widow, what are left behind the eligible child or children from another wife is not covered. That means first wife is alive.
No, you are reading the note.
No, Proviso. Proviso to Rule 104. Above 104A.
Yes.
Why did when the government servant or pensioner is survived by widow, what is left behind eligible child or children from another wife? He is not alive. Eligible child or children shall be entitled to same share of family pension.
What is the date of this proviso? This proviso is of which date?
2007.
How you are saying 2007?
Page 42 on the country left hand side. 104 proviso last part.
3, Proviso 3. No.
104, sir. 104. For last.
No, you please see just above 104A, just above that, in bracket. In a bracket.
Above 104.
Provided that where the deceased government servant.
This is government servant or pensioner is
Yes.
survived by widow, but has left behind eligible child or children from another wife who is not alive. The eligible child or children shall be entitled to the share of the family pension which the mother would have received if she had been alive at the time of the government servant.
Therefore, this is precisely what we are saying. Only if the mother is not there, the child is entitled. Correct. So that whether in respect of the children, the rule is uniform. Whether child from first marriage or second marriage, they will get only if the mother is not there. The rule is so the rule as of now what we have seen does not discriminate or does not allow any discriminatory treatment between the children from the first or second wife. They are considering the children at par.
But they will get after they get the first wife.
Correct. Even the first wife offspring will not get, only get after the first wife.
Yeah.
So everybody is at par. So therefore make an exercise. You make an exercise. If you can make them sit together.
But it had earlier we had tried, but it had failed because as per instruction received, there had been a severe abusive languages were used, and my lord, from the writ petition itself, it would also be seen.
See, we don't want them to be party to this exercise. Both of you can go for mediation. We can appoint a mediator to submit a report within 4 weeks or 6 weeks, whatever is all right. Because if a solution is found, it will bring to rest the entire issue. Otherwise, after this, whichever side loses, they will litigate. Whichever side, we don't know. Today, we don't know whether you will lose or he will lose.
Well, let us come back with the instruction. Lord.
All right.
Let us come back.
The learned advocate.
We shall express the prima facie view taken by the.
You know better.
Yes.
You have read the provisions, whether it is our view or not. The learned
Instead of 24th, can it be 25th?
After he leaves, then you have to.
I will talk with him.
Then it will not come. Then it will come on the Monday after that.
Let it be.
Then we can have it on 2nd or 9th, whatever you say.
Let it be 24th.
Second. Second is the next Monday. We can have it on. Second March.
Item number 10.
Lordship, praying for not today, Your Lordship. This one.
Why, madam?
Your Lordship, Mr. Basu is on his legs before court number 16.
Not today.
Grateful, Your Lordship.
Item number 11.
Lord, I'm praying for not this week.
One further week. A week's adjournment is sought for complying with the last order dated 9/2/26. We adjourn the matter. Let copy of the supplementary affidavit be
Item number 12. My lord, in this matter, I am for the petitioner, my lord.
Yes, sir.
I am led by my Vigilance officer. Last occasion, Lordship directed the PSC, London Airport by PSC to file the
API
additional.
report.
Yes, you are right.
Where is she?
Just told outside, my lord. It is not affirmed, my lord. Oh, yes.
I'm appearing on behalf of Public Service Commission. Lord, in the earlier occasion, Lordship.
Filing affidavit.
But that affidavit was prepared. It was sent to the department for vetting, my lord. Today, we will affirm the affidavit, my lord. I am seeking 1 day accommodation.
Learned advocate for the
my lord
commission submits that affidavit in terms of the last order dated 2/2/26 is in process.
Item number 13.
Any copy served on you?
My lord, a copy of the that is medical attendance rules has been served to me.
That is what was required to be served. It is that case where he was, while he was going a checkup, he was
Yes.
detected with some cardiac ailment.
Arrest, and then my lord, I admitted in a hospital, and within 3 months, my lord, after 1 month, I filed my lord application for disease reimbursement of
So an
my
objection why prior
prior permission has not been taken by the authority concerned.
where is the residuary provision?
My lord, these rule most probably, my lord, not applicable to me, because if your lordship the exceptional clause, that is, my lord, 2 1 subclause 2, they shall apply to all persons in the whole time service of the government of West Bengal, including their families, excepting those who are governed by the Secretary of State Services Medical Attendance Rules 1954. These rules shall be applicable to the government servants and their families when such government servants are on duty, on leave, or under suspenses, but shall not apply to those government servants who are outside India on leave or deputation, provided that such members of the families of such government servants as do not accompany them shall continue to be governed by these rules. B, this is applicable to me, retired government servants. And C is, my lord, deleted. D is government servants on foreign service or on deputation unless specially authorized.
So it applies to you.
My lord, I am retired government servants. When the cardiac arrest has been occurred, my lord, on that time I was already.
And your reimbursement is under which rule?
My lord, reimbursement under 2008 rules. 2008 rules, and then that was 2014 rules.
That is part of the writ record.
My lord, supplementary affidavit. And one memo that is applicable to me, that was annexed in the writ application. Memo dated 2018.
So where are the relevant provisions? Please give us the page numbers
Page number 75
of
my writ application.
Of your?
Of my application, writ application. Page 75.
This is only regarding the time.
Yes.
Page 75 is only regarding time. It says as per existing norms. Where are the existing norms?
My lord, they are rejected in twofold. I am not taking prior permission, and I am not, my lord, submitted my reimbursement within timeline, within time limit.
Very good. Again.
And this was, my lord, in favor of me, that within 3 months, my lord, I have to submit the application.
We are asking you, where is the existing norms?
My lord, existing norms, that is in 2008 and 2014.
Where is that?
2008, my lord, 5C on my supplementary affidavit. But there was nothing.
2008 is that?
Is my lord annexing in my supplementary affidavit.
Page?
5C onwards. Chennai Apple. My lord, but nowhere it was stated that I am not, my lord, I am not entitled to get the medical benefit in 2008. Nowhere. And 5E serial number 6 is the medical attendance and treatment as an indoor patient.
This is also for employee. How it is applying to a retired government servant?
My lord, that is in the first. Uh, On page 6 is 2014 rules that retired employee also malad entitled to get under the scheme of 2008. Page 6 supplemented. 2014, but that empowers me. The governor is pleased hereby to make with immediate effect the following scheme for the benefit of the state government officers and employees, state government pensioners, including family pensioners, all India services officers, AIS pensioners, including family pensioners and their eligible family members for undergoing cashless medical treatment facility in enlisted hospitals up to a certain limit, namely such and such.
So prior to 2004, the pensioners were not getting reimbursement. Prior to 2014.
No.
What is HCO?
Malad HCO, that is
Healthcare of
healthcare officer.
CO is defined anywhere.
HCO, Malad, that is page 8. The definition is there. Healthcare organization.
And there is another term, GAA.
GAA. GAA is page 7, clause H.
Government
Government
authorized agency.
authorized agency.
So that means the treatment center.
Yes. Page 11, serial number 12, my lord, in extreme emergency or life-threatening situation.
Correct. That is why we were asking you. That is why we wanted you to produce these. In every rule, there is such a similar provision. Otherwise, it will not serve its purpose. And you have got the treatment done on which date?
My lord, from 6 February 2024 to 9 February 2024, I admitted in a hospital.
And when did you submit the bill?
Yes, submit the bill, my lord, on 2024. My lord, that is I annex the document.
2024.
Yes. Up 2024.
When did you
Yes, yes,
submit?
I showing here.
When did you submit your claim?
My page 45. 24th February 2024.
Page 45.
Page 43 and 45. '23 to 2024. And 24 to 2024.
45 of?
Of my writ application, 43 and 45.
There is any receiving?
Malad receiving, that is
Let us know.
Malad, that is they received, if your lordship, Malad, page 48 onwards, list of submitted reimbursement claims that was from one table to another, Malad, that is forwarded by the authority. And page 49.
28/3/24.
Yes, page 49, Malad, the respondent authority stated that your claim for currently under process in West Bengal Police Directorate, and it is page 49, 49.
What is the date?
Malad, that is the date on 12/8/2024. That is claim application ID number such and such. Hospital names Apollo Hospital, Chennai, Tamil Nadu. Amount claim such and such. And then claim status. Your claim is currently under process.
The process means whether it is submitted in time or not, that we are asking you. Under process, it can be kept under.
Within time, my lord,
Where is the document in support of that? Because these two representations do not bear any receiving. So what is the date of submission.
স্পিড পোস্টটা তো পাঠিয়েছে। না না ওই ডেটে ওখানটায় ওটা লেখা নেই। পেজ 53 তে আছে। এই এদিকগুলো এটা অনেক পরে, এটা রিপ্রেজেন্টেশন। That was receiving is not that.
Come to page 48, madam. The date is there.
Page 48. Twenty 8/3/2024.
Yes.
List of submitted reimbursement.
It was submitted on 28th March.
Well, that is 23rd February 2024. As per instruction of my client, that was submitted to the deputy.
That you have already said, but there is no document. The only document is page 48. Which
Page 48.
shows 28/3/24. We don't know whether prior to this there is any document. We could not find anything unless you can show that there is any other document showing any other date.
My lord, then one representation made, that is page 53. Reminder letter.
No, that is not the point. The point is when it was submitted. That is all.
না ওটা রিসিভিংটা নেই। এটা রিপ্রেজেন্টেশন। ও যাচ্ছে না। Unacceptable.
So this is a cashless system.
Yes.
Then you are the beneficiary. So this money is not to be paid to you.
No. And for that reason, my lord, I made application before the authority. No single amount has been paid.
Apollo has not been paid.
No.
They are also parties here.
Yes. No, yeah, look at it.
Where is the rejection order?
My lord, rejection order is page 56.
$56.
Yes, my lord. 56 of my deed application.
So this is one of the HCO.
Yes.
This hospital Chennai is one of the HCO.
Yes.
Panel
yes,
HCO.
Yes. Chennai hospital within. Yeah. I mean, I annexed.
Where have you said regarding them being a HCO?
I annexed the list of empaneled hospitals.
Where is that?
That is page 60 onwards.
So where is this hospital?
Yes, my lord, I am sorry. Well, that is page 67. Seven. Serial number 7. Specialty hospitals under WBHS outside West Bengal. Name of hospitals. That is then 1, 3, 6.
This does not say, page 56 does not say that it is being rejected because it was not submitted within a month.
This was rejected only on the ground that prior permission has not been taken.
Just now you said that there are 2 grounds for
Well,
rejection.
that is one ground, that is prior permission, and 2008 rules, 2014 rules, there was nothing has been stated.
Just now you said that on 2 grounds it has been rejected.
Well, only that is no prior permission has been taken.
Yes, sir.
My lord, we can submit for reimbursement by using the portal. I'm asking this to myself. But when there is a provision since 2022, the petitioner could not approach the portal and submit a prior permission, my lord.
No.
The petitioner is using the portal to submit his claim, my lord. But in the year 2000, to the notification, the bunch of notification which I handed over on the last occasion, my lord, before your lordships, if your lordship takes up his last.
No, it is what is she what this petitioner is supposed.
Prior permission, well, this is the rule, my lord. The prior permission for outside the state of West Bengal is required. It's a mandatory.
Where is that in 2008 or 2014 scheme?
My lord, the compilation is there, my lord, which I showed you. Lord.
Earlier case, dear case. The one which we have adjourned for taking instruction in that case. Compilation. The one which is filed by the petitioner.
No, by us, my lord, on the last occasion. Well, we just compilation. Starts with the finance department audit branches notification.
Yes. This is a,
This is the 2008 rules, my lord.
so it is the same which she has submitted today.
2008 my lord, are not applicable to me, only that is employee. My lord, these schemes shall apply to the employee and his beneficiary. I am the retired employee. I am governed by the 2014 rules, not 2008.
2014 is for cashless treatment. That is not laying down who is eligible and who is not eligible. That is only laying down the modus of cashless claim. So your eligibility has to be founded on some earlier rule. That does not give the who is eligible. That gives the mode of claiming the by the HCO to claim it cashless, how it is to be done.
My lord, her claim was rejected solely on the ground that permission was not there.
So where is the requirement to obtain the permission prior?
Page 16 of the compilation. The amendment that took place on 30th of July 2010. Page 16, point number 14, my lord, bottom portion. Treatment in a hospital or institution outside the state. If my lord kindly takes up page 17, point number 2, it has been said that prior approval of the Secretary of the Department shall be obtained before receiving medical attendance and treatment in these hospitals or institutions. And even in the year 2022, my lord, an online facility has been granted to them where they could have easily.
You are saying this will not apply to you. You have not read this.
Yes.
Read page 17, clause 16.
Clause 16, applicable benefits, retired government employee. Give any different. Enhance employment.
Yes. So you are relying on the notification of 21/8/2018 and 17/1/22, page 23 and 24 of this compilation. And which other provision? Page 17.
Page 17. That is the relevant provision. Online facility has also.
14.2.
14. That is. 14.
Yes, regarding that online only we are saying page
Could have
20.
easily accessed it. The
Page
patient
24 is the page 24 is the online.
That facility has also been granted back in 20.
But if that is not done, what is the consequence?
My lord, if your lordship takes up page 17.
Huh?
Page 7.
No, what is the consequence for failure to
Yeah,
obtain
that,
a...
I'm showing that.
Yes.
17 of compilation.
Yes.
Point 17. 17.
Yes.
If very difficult to write the course of implementation, it shall be referred. Finance department and the finance department, they are all shall be fine.
So did you do this in this case?
It was rejected because of prior year. It was rejected on the face. The lordships can refer it to the finance department, then ask the finance department to take a final decision in this regard.
In her application, in her claim application, in his claim application, did he state that when he had gone for a checkup, it was detected and immediately surgery was required?
Yes,
Let me go through it thoroughly, then come back. That too, my lord, I can come.
that was my lord stated.
Therefore, once it is said, then that is a difficulty in obtaining the prior permission. How one can obtain when one is...
My lord, your lordship knows it better than me. As on date, my lord, in the year 2024, even a mobile phone will suffice, my lord.
It will be after the procedure. It cannot be before the procedure.
Whenever
If one is in the hospital and undergoing a checkup and doctor says immediately this has to be done, he will get off the stretcher and look for an email and make it.
Remember, I'm not saying that he should be getting up.
Not possible. Then what is the effect? Therefore, we are asking you. If this difficulty has been expressed, there is a provision under 17.2 that the finance department is required to consider. Why it has not considered? And why mechanically it has been rejected? Is the claim forced, false, fabricated? Is it anybody's case that he has not undergone the procedure?
No, it was
What kind of implementation of the rule you are making? First, you say it is applicable to all emergency. You can deal with in this way. There is a authority to look into difficulty, and then you reject mechanically. Is there any other provision?
Then I'll come back.
No, we what come back? This has to end. This cannot be allowed.
Give us a short date. We'll come back taking this clarification.
What clarification? You have annexed the entire bunch. No question of any
Madam,
clarification.
I'll seek a further clarification on Lordship's.
Not required, sir. There is no consideration by any authority. We have seen that. We'll come back and we'll pass the order.
Right.
We'll pass the order today.
Milord, that compelling circumstances, Milord will kindly not take me amiss for mentioning at this hour. On 10th of February, Milord, the order was passed with regard to police recruitment, Milord. Basically, they have an effect of more than 8,000 people's application, and it was supposed to be implemented by 17th of February, which is tomorrow. Milord, we had applied for the certified copy on 13th February, Milord. We pursued it, Milord. Even today morning also we pursued it, Milord, but the files have not gone down, so Milord, we are not in a position to get the certified copy. But if we can get a leave, Milord, to file without certified copy and without offline, Milord, because there is a state authority which is before, Milord. It is a bit of urgent, Milord, because the order has been passed allowing appeals to be heard made by the applicants before the authorities, Milord, which is beyond the scope of the rules as per. So it is a bit urgent, Milord, and we are in a
What urgent? Tomorrow is the last day. Whether you file today or not, what difference does it make?
Well,
How is it going to change anything?
But let us be allowed, Milord, to file it.
So it's
without
just a question of filing. You can file one day later also. What is the big deal?
certified copies have yet made. There is no latches on our part, Milord.
13th you have applied.
13th, Milord, we have.
We just weekend is intervening and today you are mentioning.
Milord,
Why
10th
didn't you
was the
apply?
Order was.
Why didn't you apply on 10, 11, 12?
Milord, the difficulty is, Milord, for a appeal to be taken, to be decided, Milord, Milord knows it is an impersonal machinery, Milord. We have to take the approval of.
So you may take all the time and then once you get here, everything has to be done by the court.
I'm not praying for.
You get the certified copy.
I'm just
You get the certified copy. If there was something, order was required to be passed, we could have understood. You file it. Let us see.
Heard tomorrow.
Yes, we were held up by some meeting. Sorry, we are late 10-15 minutes. Yes. Call it. Now 2 p.m. D. Hmm. Go on. Go on. Phone आगे तो Bluetooth को- It has been informed. On the last occasion,
My lord was pleased to, my lord, direct my learned junior to serve a copy of the notice to the learned government pleader. Now, in obedience to my lord's directions, my lord, it has been served and they have also received. They said, my lord, this is the letter. Dinda. My lord, I am told that Mr. Dibangshu Dinda is appearing in this matter.
So he's the government pleader is the higher government
Yes,
law officer.
yes. And but I apprehend, I should be very clear to my lords. Now, my learned friend is appearing on behalf of Public Service Commission. Now, my lord, I make my submissions. Now, then, my lord, the state will come and say, my lord, that they are not aware, or they. My lord,
Why you wanted them to be?
that's a thing, my lord. My learned junior, my lord, was very diligent in his efforts, my lord. He had given a notice indicating that this matter will be taken up, and the.
So otherwise, what is the system? All the notices are to be served on the officials
Yes,
directly or not on the GP?
My lord, to the office of the learned government pleader, if your lordship so directs, I say, my lord, as an alternative, I can also do this thing. What falls for my lord's kind consideration? Government office of the learned government pleader, along with the learned advocate who has been engaged, we can give a notice to him and then come up to the court, my lord, as per the convenience of the court. Otherwise, my lord, he is not in a position to know what are the submissions, my lord, which are being made.
What do you suggest? What is the best?
So I say, my lord, that it would be fair or it would be, my lord, appropriate for me to give a notice to the concerned learned advocate appearing for the state, along with a notice to the learned government pleader as an abundant caution.
Yes, you also want to say something.
I'm appearing on behalf of Public Service Commission.
No, we thought that you are prompting him to say something.
Yes, she is suggesting that whether the court can appoint the advocate or someone.
There is nobody here. See, whether we appoint or we direct, the exercise of serving will have to be done.
Exactly.
So therefore, why not continue with the same person?
Milord, it would also not be, I say, Milord, kindly do not take me amiss, Milord. It would not be proper, Milord, on our part, Milord, to proceed with the matter.
But I find it from my experience in my parent high court, this cannot happen. Once you have informed the law officer, it was his duty to tell his junior that you go and junior law officer that you go and appear in this matter. It is fixed on such and such date. Why should he
I say, Milord, but only thing, since the concerned learned advocate has not been given, therefore, Milord, a defense can be taken that it has been served upon the office of the learned government leader, not upon the concerned learned advocate.
that? So that is why I asked, what is the system?
Milord,
Here we have a system that there is a
Says that to serve notice upon the office of the
Yes,
government leader,
yes.
then it is suffice, nothing more. Now it is their duty.
that we have understood, but that is our direction. Otherwise, there is no such system.
Number two, Milord, on account of change of lawyer, counsel, Milord, initially Mr. Bishopbrata Boshamulli was there.
Oh,
Yes.
so it is one of those cases in which earlier he was appeared.
Yes. And that is why this has happened. Even then, for abundant caution, as my senior has pointed out, we can serve a notice upon Mr. Dinda, we know him. And last Friday, Milord, the supplementary affidavit along with this notice, Milord, supplementary affidavit was served upon the state. Mr. Dinda, Mr. Dinda personally received
He has received,
the supplementary affidavit.
but he has not received the fixing of the
It
date.
was not addressed to him.
So just communicate this to him. He must be having the files.
So Milord, the matter will appear on.
Kindly take up the matter in a way that after two, which permits my
Normally, the court records, that is our
the
experience.
diary of the court, if it permits, kindly fix up it.
Yes, what are you saying?
Yes, Milord, I was saying, Milord, that if the court says that if the notice is served upon the concerned advocate, Milord, if they choose not to appear, Milord, then the court will proceed.
No, this, in my opinion, is enough. But if here there is no such system, then what can be done?
Your lordships will follow your lordship's own system. Milord.
No, I cannot. I'll have to follow a system which is in practice here. I want to go by that, unless
I tell you,
I find an occasion to
I
change
tell
the
you,
system
I
by
tell you,
some.
your lordship, Milord, it is our experience which is very certain and definite. We have seen many honorable judges, Milord, after beholding this notice, Milord, the court, Milord, passed an order and Milord proceeds with it. Many a times we have seen. Since your lordships have taken a very liberal stand, so far as Milord, we can serve.
As an abundant caution is,
Mr. Amol Sen has come.
Yes, I can see
Then maybe
him.
requested.
I can see him.
Yes.
Mr. Sen, can you please?
Mr. Dey is also here, Milord.
See, we have sent a notice to the learned GP, still nobody is appearing.
যে লয়ার আছে তাকে একটা নোটিশ করে দিই করে
Order
তারপরে।
courted order also.
The GP
Mr.
office
Dinda
should be advised that once a court says, they should at least intimate the learned advocate who is entrusted with the matter.
Under these circumstances, Malad, the GP office, they should Malad, ensure that actually who is engaged, who has been engaged in this matter, and communication is to be Malad, forwarded to him. I do not know whether if it has not done. Malad,
Because our order specifically fixes the date and time both. There is no ambiguity.
My lord, kindly fix it, madam. Any other day, madam. I personally, I should communicate that who is appearing.
আমরা appearing counsel পেয়ে গেছি দিনটা।
Despite notice served on the office of the learned GP, there is none to appear on behalf of the state. Mr. Amal Sen, learned AG, who is present in court.
I do not claim any seniority.
No seniority of the case number.
I tell you, Lordship, Milord,
Seniority.
as I always say in other courts also, they have kindly take up the matter in the last.
He does not claim. He has been conferred. He need not claim.
That is the,
Yes.
he also said it today.
Item number 13.
Item number 13 Milord, প্রদীপটা এদিকে আছে, ডান দিকে। Lord, I was appearing for the state, Milord, kindly excuse me because first half I was not there.
No
Milord,
problem.
learned
As
teacher
long
has
as
addressed me.
he has given, if there is anything left, you are more than
Milord,
welcome.
one thing, Milord, Milord, must draw your lordship's kind attention that, Milord, your lordship is taking that, so far my understanding is concerned, Milord.
Please,
Page 17
please, 1 minute, bear with us. As of now, his submission is, there is a 2008 provision and there is a 2014 provision. The provisions harmoniously read require that the claim cannot be raised unless the treatment is preceded by sanction because it is outside state.
Page 17.
Second thing is that it was required to be submitted within 1 month. We asked him a query. What is the consequence?
Milord, third submission was that, Milord, it was the duty of the petitioner to submit through mobile from hospital or his key.
Therefore, substantially an offshoot of the first.
He has not opted that.
Substantially an offshoot
This
of
is
the first
link
point.
of the submission.
Now the issue with the query we made is, what is the consequence of failure for doing so in the rule? Where is the consequence that if it is not done,
My lord,
then
if
what is
you-
the consequence?
If your lordship, Milord, if your lordship takes, Milord, compilation page 17, point number 17.2. If any difficulty arises in course of implementation of the scheme, my lord, on this point, Milord, my respectful submission is this, Milord. Again, I'm repeating, my lord, with your lordship's kind permission, Milord, I am repeating, Milord. If any difficulty arises in course of implementation of the scheme, my respectful submission is that there was no difficulty from anybody's part. My lord, kindly don't take me amiss, Milord. It is the negligence from the part of the petitioner. Milord, due respect, Milord, with my respectful submission, I would like to submit, Milord, if any difficulty arise, my submission is there was no difficulty to submit, Milord, anything. No difficulty. Because, Milord, from online, mobile, it was there. His kith and kin, neighbor, relatives were there. So, Milord, it was the duty of the petitioner to submit this. So, my lord, I think, my lord, kind to subject to lordship's kind at the correction. My submission is thus, my lord, if any difficulty arises, clause is not applicable. Be that as it may, my lord, I would like to submit on this contest, my lord. If your lordship thinks it fit and proper, your lordship may refer it to the finance department for its correction. My lord, finance department will take
Where
steps.
your officer has said that it is a negligence, there was no difficulty. Please show from your officer's affidavit.
My lord,
Whether there was a difficulty, whether there was no difficulty, how much time he had, how many relatives were there with him. Where is the consideration of this aspect?
my respectful submission
You
is
cannot
this, my lord.
submit something without facts, without there being a factual foundation.
My lord, kindly
Without a factual foundation, you cannot make any submission.
as an officer of your
How can you?
lordship's
That
court,
is
my
why
lord,
we are saying
I cannot submit.
you are creature of instruction. You cannot do something or say something which is not there in the affidavit.
I cannot submit, my lord, without
What
pleadings.
kind of submission you are making?
Pleadings, my lord,
There
I
is no
cannot
difficulty, there is negligence, there is no finding. And we have to
without-
record with that there is a negligence.
My
What
lord,
kind of submission?
My lord, don't take me amiss, my lord.
What a
Without-
miss. We are asking you how you can make a submission without a factual foundation.
That, my lord, I'm trying to clarify, my lord. Kindly.
First, you should have shown the fact. Then you could have made such a submission.
My lord, my
You are attributing malified or negligence on them when no such a stand is taken by the authority.
My lord,
How can you do so as a counselor?
kindly appreciate one thing,
What
my lord.
appreciate, sir? First clarify this aspect, whether it is open for any counsel, forget about state counsel, to make out a case which is not there in the affidavit. Then
Without pleadings, my lord, no one can submit anything.
Then how you are making
Please
such
tell
a
me, lord.
submission? You
But, my lord,
cannot,
kindly visualize one thing,
cannot
my lord.
make such submission. We will not visualize something for which there is no factual foundation.
Bow down before your
We will
lordship.
never
My
do
lord,
this.
kindly appreciate
We will
one
never,
aspect
we
of
will
this.
never permit you or them, either of the sides, to
My
do
lord,
this.
kindly appreciate one aspect of this matter. my lord.
When you make a submission,
Common
you are
sense,
expected
lord.
to make a submission with some sense of responsibility, founded in the factual foundations, in the brief and the pleading.
My lord, my
You
lord,
just say anything. How can you say such a thing?
My
He has rightly not said anything like that.
my
He
lord,
cannot.
my lord, my respectful.
What you are saying is 17(2) not applicable because I feel there is a negligence. Wonderful thing for a counsel to submit.
My lord, my humble understanding is this, my lord. It is common, my lord, my common prudence, my lord, that one who was
Cannot
very
make
much.
submissions on common prudence which are required to be substantiated by facts.
My lord, my lord, then, my
It's
lord,
a
I
very
will.
basic rule of advocacy. We all know that.
My lord, my lord, then, my lord, kindly refer it to the finance department, my lord.
Submission.
Finance department will consider.
Negligence.
My lord, my lord, kindly ignore my submission. My lord, my respectful in, my lord,
Such submission.
my lord, kindly, my lord.
Can understand in zeal and enthusiasm some petitioner or advocate saying the state. When it's not the state's case, a state lawyer will submit like this. You are bound by a higher degree of
Lord,
everything.
I have, my lord, always bound to submit as per our pleadings. It is not there, my
You are
lord.
expecting
So-
that you will add something better. You are not. You are saying something for which there is no foundation. And you are asking us that we should consider this submission. Therefore, we said, show us the factual foundation. There is nothing.
Yes, that's true.
They are only saying there is no prior permission, nothing. That's all. Mechanical rejection, showing total non-application of mind. The court's query is, what is the consequence of failure? Please show us or say that there is no consequence. You must take a stand.
My lord, there was no recording in pleadings. There is nothing, my lord. Kindly refer this matter to the finance department.
Yes, it
Finance
was
department
required
will
to be. It was required to be looked into. There is a provision
Yes, my lord.
which says that in case of difficulty. Therefore, we asked whether in the application they have stated that it was during a checkup that the disease
Yes,
was detected. Where is that we were going to see? Where is it? Which page?
That is my lord, page 43.
Page 134.
Page 43 of my deed application.
43.
43. And with due respect, I such and such, having West Bengal Health Scheme Enrollment ID number such and such and PPO number such and such, under Mirik Treasury, would like to inform you that on 1st February 2024, I visited Apollo Hospital, Chennai for my routine medical checkup. My Apollo ID number such and such. On the same day, I suddenly experienced severe chest pain and excessive sweating following which I immediately consulted Dr. such and such, a cardiologist at the same hospital. The doctor immediately advised a thorough heart investigation. After the investigation, it was found that I had double vessel disease and mild LAD, had 100% chronic total occlusion. The doctor, after the investigation, suggested immediate precaution transmineral such and such to avoid any risk involving my life and to improve my life expectancy, as this was a severe heart related problem. Due to the sudden unanticipated nature of this unfortunate event, I had no alternative but to follow my doctor's advice of immediate medical treatment and undergo the said surgery without wasting any more time to save my life. In these circumstances, I was not in a position to obtain prior permission from the concerned authority. Consequently, my prayer may kindly be condoned in this situation of medical urgency.
They have
Hence,
filed, they have filed any opposition
no, my
before the tribunal, any reply?
no. Tribunal, no opposition has been sought for. Only one day, and that day dismissed.
Same day.
Same day.
And the rejection order is at which page?
My lord, that is 158.
No, not rejection by the tribunal, rejection by the authorities.
Authorities, my lord, that is page 56.
Yes. Probably. And this 2000 rule, 8 rule is also there in your supplementary.
Yes, 2008 and 2014 in my
Both.
supplementary.
And is there any financial limit to the expense? Is it within that limit?
That is not stated anything, the financial limit.
No, in the rejection, they have only said about no prior permission. Yes, take down. The writ petitioner
instead of allowed, my lord, kindly mark it disposed.
We are allowing it, we are quashing it. We will not encourage such rejection, sorry. You can continue this. People are, unless you doubt the genuineness of a claim,
Yes,
no prior approval and all these things, somebody will die for your approval. You want approval. Yes.
14.
My lord, I'm for the petitioner being led by Mr. Sudipto Dasgupta, my lord. My lord, I pray for a day's accommodation, my lord. He's engaged in a matter, my lord.
Not today.
A day's accommodation.
As stated by learned advocate for the petitioner matters adjourned for the day.
Yes, man.
What happened?
Every day I am waiting for this matter.
That is why we recorded the order.
My lord, you are just here, my lord. A matter is taken up.
That is why we recorded the order. We appreciate your waiting, therefore we have recorded.
Number 15.
Is on this, there is an issue that used to come. Yes. If there is a financial limit, it is. That's why they are admitted.
My lord, I am for the petitioner led by Mr. Orno Banerjee. My lord, he is currently engaged in court number 11. My lord, kindly be adjourned for today, or otherwise, your lordship may keep it on Monday.
Today again an adjournment is sought for. Taking adjournment.
Wait, please, your lordships.
For the respondent number 1.
Lordship considered the matter, then also asked us to settle if could be settled. The short point, Lord, which emanates from the entire is EMP 251. Whether that could be given the go by.
2008.
Yes.
MP 251 of 2008.
Yes. Whether that could be given the go by the tribunal has ultimately passed that direction, that give the go by, and their application before the tribunal said that EMP 251 is not binding as such. They blow hot and cold on the same point. They are asking for relief from that, and they say that it is not mandatory.
No, what was the substantial relief they sought before the tribunal?
Grant of appointment in the compassionate category.
Who was the
Unmarried
claimant there?
daughter.
Unmarried daughter.
I am the mother, and he is for the married daughter. And we have a substantial prayer before your lordship that the married daughter be given, because 251 EMP cannot be given the go. Because NOC has to be obtained from us.
So without NOC, the tribunal has directed.
That is the short point. And I'll show you your lordship a judgment where my lord justice was there with judgment of the where it has been held that this cannot be done. My lord has, sitting with my lord Justice Tandon, had passed the order in a different matter and different.
So all we are required to see is whether 251 contemplates NOC as an essential requirement or not. That is all. Let us see 251.
Yes, ma'am.
But after he submits, my lord, we have got, other than that, a few more submissions. We'll be advancing that.
No, anything else the tribunal has directed?
My lord, I say this, my lord, that the substantial relief which the mother has come up over here. Number one, my lord, this petition is liable to be dismissed as because she is age barred. The mother cannot come in the way, number one. And my lord, the other daughter, she has not assailed the order of the tribunal before your lordships. Lordships may kindly take a look at the array of the petitioners who has come before your lordships. Kindly have a look, lordships, at the cause title. At page 1 of the writ petition, it is Shantirani Das, age 60 years. She has come up before your lordship, but not Shantirani.
Second daughter is a married daughter.
Yes, she has not come up. Wife of Animesh Giri, she is a married daughter. She has not come up. Nambala, there was a reasoned order passed.
No, we are not on that who will get. We are saying whether NOC can be exempted. That is the only thing.
There is very well, my lord, but I will be relying.
Whether they will get, she may not get if you don't give NOC. We don't know. We are not there yet.
My lord, I am on the one of the primary questions that in this writ petition, Rubirani Giri cannot get the benefit because the reasoned order which was passed, that was challenged by me for the tribunal. He did not challenge the reasoned order before the tribunal.
There was an application, MA, before the learned tribunal because of the change of circumstances.
He did not challenge it.
I believe my learned friend will have to
Number
take
one.
his seat first.
Because
where is the OA?
OA, my lord.
Page,
my lord. It will be in the first volume.
Page 25, let's start from volume.
बोलो.
So you arrayed her as respondent number 4.
Yes.
And the mother as respondent number 5.
Yes, but now.
And where is the impugned order?
My lord, it would be in the second volume.
No, impugned order before the tribunal. Page
before
58.
the
Page 58.
No. Reasoned order. Second.
Put an impugned order of the land.
Sir, please see page 58, please. Please have.
ওখানে চ্যালেঞ্জ করেছে ও যেটা.
Yes.
Before you say no, at least have a look when we ask.
I'm sorry, my
Yes.
টাইপ করা আছে তো? এটা টাইপ করা আছে?
This was challenged by me. Ruby Rani Giri did not challenge this. Only the
The relevant portion would be at page 62, my lord. Second paragraph. Hence,
and my lord, I am relying upon just the first paragraph there too, page 62. Ruby Rani Dasgiri in terms of decision referred to above.
Please allow us.
My lord.
take a better copy. Your কাছে কি দেওয়া আছে? Oh.
No, that's okay.
না না, ওটাই পড়ছে পুরো ফাইলটাই পড়ছে এখানে।
এই তো নিট এন্ড ক্লিন কপি আছে। শো সেখানে কোথাও yes. বাজে জেরক্স করে দিচ্ছে করাই যাচ্ছে
NOC is mandatory or not?
Yes.
Because your claim was allowed by the authority. You are not satisfied because he said this is subject to production of NOC and an undertaking that you will maintain them.
Yes,
So you say I will.
required. Undertaking.
Where have you said in the OA that you are willing to, you are ready to maintain them?
My way.
In your OA, where have you said?
Undertaking is
only one thing.
Just let him.
Undertaking the one. অর্ডারে বলা আছে না হ্যাঁ কি বলছে in the order it has been recorded, page 236. The order it has been recorded in the middle portion.
You have already given such an undertaking.
Internal page 3. Well, initially, my challenge is to Ruby Rani Dasgiri, who has come up. I would primarily take this point that she cannot get a relief in this writ petition, not having assailed the parent order before the learned tribunal. Therefore, the reasoned order has become binding in our case as of now, as of this date. Now, this is my primary one of the objections, my lord.
Which has become binding?
The rescind order which has been passed. Which
It is
was-
binding. Should we record your submission and dispose of
No,
the
no.
writ petition?
No, it is one of the objections I am saying.
No, you are saying it is binding, then
No, no,
nothing
binding on Rubilani Dasgiri.
on them only, not on you.
No, definitely upon me, but I have assailed the part of it.
Sir, when you say that it is binding, then there is nothing left. We'll just record that this is your submission and we'll dispose of.
Well,
They will also go home happy and
No, well, I take
you will
back-
also be happy.
Well, I take back, my lord. I learn every day.
See, we understand what you are trying to submit.
Right,
That's
that's-
nothing more than a technical objection. Why should they challenge that order? They know that they only if they give NOC, you will get it.
And
If they don't give NOC, you will not get it. That there is no requirement of challenging that. So therefore, whatever you may argue, the core issue to be considered is whether NOC is mandatory or not. Whatever you may argue, that is the issue to be considered, whether NOC is mandatory or not. Let us see the 2251 EMP, what it says about NOC.
And Milord, only one more thing, Milord. We had filed an MA before the learned tribunal because of the change of situation, so that the married daughter could get that MA was disposed of without passing any order.
No, but
That
you are not challenged any order.
that is under challenge here.
Here,
Because
you have challenged.
yes, Milord, Lordship will see that.
No, in this writ proceeding, you have filed any.
No, Milord, what I mean to say, Milord, I'm sorry if I have not been able to explain.
No, we understand. In the tribunal, you said that in view of changed circumstances, you filed a miscellaneous application which the tribunal did not allow.
Did not consider also.
Maybe did not consider. If that is so, and if you are aggrieved, then you would have challenged that.
That is here. This order.
Oh, that is the order.
Yes. That is also part of the main order.
Yes. Where is that MA which you filed?
Let
us see that.
Page,
also.
Milord, is page 199.
But this writ petition is filed by you.
My lord, the mother.
The mother.
What is your prayer in the MA?
MA. My lord, the prayer.
For appointment of respondent number 4.
Yes.
Page 209.
Yes, I'm grateful. And this MA, Lord, how it was considered, Lord, Lordship kindly takes up the order passed, second volume.
Second page.
Second volume of the order of the learned trial.
Yes.
Oh, my lord, it's at the next page. I'm sorry, my lord. It's the last annexure. My lord, the order is dated 7/8, same date, in MA 69.
Oh, yes. One page.
Yes, my lord, one page. Matter is taken up by the single bench pursuant to the order issued in exercise of the power. Since the original application is disposed of, no order is required.
So the MA has been disposed of after the OA.
After the OA.
Yes.
I'm grateful, my lord. My lord, the facts, my lord, if your lordship wants to see, it starts at paragraph 4 of the writ petition. The serial facts, my lord.
Will it be of any relevance?
No, subject to what?
Either
also, my lord.
NOC is required or NOC is not required.
My
That
lord,
is the only-
we have given a judgment which is in the same line by a division bench where my lord Justice Tandon sitting with my lord Justice. We take to Dina Judge Sahib.
So NOC was held to be mandatory.
No. It's not. It is a separate thing. If something has been required to be done in a particular manner,
yes,
it has to be done that way, no other way. That law is very well settled, but my lord, just to, I thought application in the prescribed format to be followed. This in Judge Sahib. My lord, probably that judgment. আগে দেখি দিই। More particularly paragraph 6, my lord. Though your lordship will read the entire. Pata?
No, this is a transfer matter.
No, not because of that, my lord. The analogy. Only because of the analogy.
No,
Though it
here,
is well settled, Supreme Court has.
here the tribunal has tried to or has more relied on the beneficial object of the act of the scheme. So therefore, this transfer will not. It's of a different. That's a settled proposition.
That's
for
right.
that.
My lord, lordship comes to the scheme, paragraph 10 of the scheme, page 115. Procedure, page 115. Procedure is 10 and my lord B. Application is to be submitted in the prescribed pro forma as in annexure A and B as applicable.
One thing we are only asking you, although our attempt has failed earlier, if you succeed, take it. If you succeed, we don't know. What will be the result? Who will get the appointment ultimately? Because if she doesn't give NOC, you will not get.
No, married daughter.
She is one of the family. She must give an NOC. And if you don't give an
She is
NOC,
not a part of the family anymore because she is living for 15 years separately. That is on record.
We don't know. But she is a offspring of the deceased government employee.
No doubt.
And daughter is one of the beneficiaries under the DCRB. So therefore, for excluding her, it will be an onerous task on you to show that she is not entitled to anything.
Because it's on record now, subject to my lord's pleasure.
That issue we are not considering today. We are just trying to foresee what will happen should you succeed. Ultimately, this will remain elusive for both of you. And for a good deal of time until we don't know when it will be settled. Therefore, on the last day, we had said that this is not going to serve any purpose. We take it, we don't know. MFSC, if we take it that you succeed, worst case for them, then they don't get. But will you get? DCRB family is defined.
No, that is right.
Family includes a daughter. So it is intended for her benefit also. Now to have her ousted from that scheme, it will be an uphill task for you. And we don't know whether you will ever achieve it or not. So litigation is for what? To achieve what end? Is it for depriving them or taking a benefit for the family? You are representing the other daughter.
Married daughter. It now.
My mother died. Application was made. Not considered by the authority. He actually tribunal party matter and both of them are. I on behalf of the married daughter. My mother.
Can you get an appointment on compassionate ground without her NOC? Can you get it under the scheme? Can you get it without her NOC under the scheme? You cannot. Must be there. You are arguing the same thing against her, that without my NOC she cannot get. Both the sisters cannot get without an NOC of the other. Why are you litigating? Why can't you resolve the issue? One of you take the appointment and maintain the other. Otherwise, it is elusive for both of you. And the state is having the last laugh. They are not having to give an appointment and not having to change. All those objections are unfounded. There is a clause in the scheme which says if there is no, if she doesn't take care, then her appointment will be cancelled because she has to give an undertaking which is renewed every year. Therefore, there is no scope for that she will not take care. Thank you for telling us. Thank you for telling us. You have enlightened us on that point. But again, we are saying that if she does not give you an undertaking and every year you do not say that yes, she is maintaining you, her appointment will be cancelled. Therefore, we said that if we find it is not sustainable, what you will get? What will you get as a relief? And how ultimately you will realize the fruits of this beneficial scheme, which is elusive only because you are quarreling?
It's a gun both way pointed out. If they win, I will take this point. If I win, they will take this point.
Therefore, we are saying
what has fallen from your
ultimately three of you are deprived of the benefit. The parties, if they don't understand this, we can understand. But lawyers must be understanding what we are saying.
The both way.
My mother.
These are all question of fact.
Now, that is the difficulty. At no point of time, she has left for 15 years, more than 15 years. And that is recorded in the order.
Again, you are saying something which is unacceptable by any legal standard. You cannot say she will not maintain you. If she does not maintain you, she will lose her job. That is impossible. That submission is impossible to accept. Therefore, we are saying the parties may think this way, but as lawyers, we are asking you, is it possible that she will not maintain? She has to renew the undertaking every year. You can't say so. Now, subject, if you find anything worth considering after our observation, then you may do so. If not, we will decide it. It will remain elusive for you even if you. Therefore, we are saying there is no other way. You please, as lawyers, you can impress upon them that look, this is ultimately this is the circumstance.
With this, with a order to that effect.
Yes. All three parties are here. Nothing is there. Yes. What is your view?
Accepting
these are all. He is going on harping on this, but not having any.
That was we were informed about this on the last. No, what is their view? We want to know. See, it is the same observation for you. Even if she gets an appointment, the moment you say she is not maintaining you, she will lose it. So therefore, in this fight, neither of you are getting anything. There is only one way to get it, that you resolve the issue. Otherwise, you will win one round of litigation, the other side will win the other round, and ultimately nobody will get anything. And when this man has died,
না একটা মাইলরের একটা বিষয় একটা দাম আছে
15 years. No, how long ago?
15 he has died.
So 10, 11 years. My God.
The earlier occasions, the settlement process has failed miserably. Now, therefore, on instructions, I am saying that he is quite skeptical that whether at this point also whether it will be.
Very well, then let us see. Let us read 251. Where is the DCRB? Yes. 251 is at which page? Sorry. 251, we'll get it. We have it. It is of 2008 or 13.
13.
2013. So where is, which clause says about NOC?
11.
But a better copy is at 101, page 101.
Just are very poor.
The relevant page is 105.
Uh, 11 is regarding undertaking, not NOC.
The procedure starts at textbook and then NOC undertaking is at
No, where is the requirement of NOC?
Page 1190.
Which clause?
Page, start from this side, page 119. Relevant part is 1.
Clause, which clause? Where is the requirement of NOC? We are repeatedly asking, you are repeatedly showing undertaking. No, give us the clause. Which clause? 11 is undertaking. NOC is in which clause?
Paragraph 4. Page 1.
Prescribed format is under the 2008 2008 EMP. No, no.
MPI of the other defendant. No objection in favor of the applicant. And after fulfilling all this, the applicant has to be served. This application has not been served.
2013. 2013. Why it is not here in this compilation?
They were at the dependent team. Signature we have on the applicant. এটাই তো বলছি এবার আমি এখানে কখন
part of action. Part of action. The second page of action.
Okay, 140, 143 or 120, 120, 127.
এখানে বলা আছে
Yes, we have got. Signature LTI of other dependents. Yes.
Lord, I say, my lord, that the persons, they are not dependent. Kindly have a look what they have showed before your lordships. The signature LTI of the other dependents of the family. Now, my lord, they are not dependent. They are having separate income. The mother who is before your lordships, she is having a separate family pension, and the other daughter, she is also having separate income as certified by the BDO.
Certified by the
BDO, Block Development Officer. That has been annexed in the supplementary.
So have you disclosed their income in clause 3 of this form submitted by you?
No form has yet been submitted. Right?
So if you submit this form, you will be required to disclose their income in clause 3. You see just above this clause requiring NOC. And if the consolidated income of the two of these persons increases above 90%, you will not get the employment. You cannot divorce yourself from their income.
I am unemployed.
You are, we understand that. But have a look at clause 3.
Particulars of all the dependents of the deceased.
Now what is the 6th column?
Living separately.
Now what is the 9th column?
Or within the family, gross salary if employed.
Employed.
I am not employed, my lord.
Particulars of occupation, employment, already employed.
Yes, if already employed.
But this is not talking about you. This is talking about all dependents of the deceased. And dependents is defined under the scheme, which includes a married daughter.
Yes, but
So you will have to give her a salary and her income and everything.
Now, my lord, I say these, but they were not dependent
All right.
on
Anything else?
Their part.
Yes.
Now, my lord, she is having her separate income.
Well, that you have already said. Yes.
Yes, my lord. And my lord, Shantirani Das, she is also having a separate income of family pension. She is received in all of that. Therefore, my lord, I say this, that they are not dependent, and it clearly.
And where is this averment in your OA regarding their income? Where is this averment?
In the supplementary we had made.
Where is your averment in the OA? Or based on which the tribunal has passed the order?
पेज धरा नहीं तो पेज तैयार होते तो हाँ ওটা তো সাপ্লিমেন্টারি কি জিনিস ছিল Lord, kindly see page 37. I have stated that natural mother of the applicant is enjoying monthly family pension. And also she got all death benefits.
Page 37.
Yes, file out of the writ petition.
Internal page 13.
Yes, my lord. Internal page 13.
Which paragraph? QR.
The last paragraph, my lord.
The natural mother.
The natural mother of the applicant is enjoying monthly family pension, and also she got all death benefit vis-a-vis the death of her applicant's father. And my lord, I was not given any share of such death benefits. On instructions, my lord, I am submitting such.
So you have not said anything about their employment. You have said that they are getting pensionary.
Therefore, my lord, I had intended to show that they are not dependent. And but the supplementary affidavit, my lord, which I have
yes.
certified by the BDO টা কোথায়? ওই ইয়ের ক্ষেত্রে না? আমাদের ক্ষেত্রে না। এটা কোথায়? হুম। তো এবারে কোনটা নিচ্ছি? Should we kindly seize the supplementary affidavit?
No, we'll not look into that.
No, that was allowed by your lordships to be placed, and that is the certificate given by the block development officer,
We don't.
which clearly stated that the
That
mother-
cannot validate the order of the tribunal which was passed without taking into consideration.
No, it was taken into consideration.
By the tribunal?
Yes.
Please show from the order.
Yes, yes. If the kindly sees, it starts from page 235. The last paragraph, the internal page 2.
Hmm?
The internal page 2, my lord, at page 230 or 230.
Yes.
Yes. In support of a statement to the effect that she neither lives with her mother, Shantirani Das, nor the mother is dependent on her, Momi Das has presented certificates from the block development officer, Mohanpur, Paschim Medinipur, stating that a biological mother, Shantirani, is self-dependent, who receives a pension benefit payment of around rupees 22,992 per month, similar to the certificate given by the block development officer, Mohanpur, Paschim Medinipur, Mr. Bikram Chandra Pradhan, member of Legislative Assembly, West Bengal, and Pradhan, Mohanpur Gram Panchayat, Mohanpur Development Block have also issued certificates in favor of Momi Das, the applicant.
So there is nothing about employment, only pension.
Yes, my lord, this is to show
There is
that-
nothing that they are employed.
No, my lord,
Pension only.
this is to show, my lord, that they are not dependent.
Dependent on whom?
They were dependent.
Now they are not dependent on whom?
But they were not dependent on the applicant. And my lord, they were also.
How that is relevant?
No, no, they are not dependent means that they are not dependent on the income of, or they were dependent on the deceased employee.
So they were not dependent on the deceased. They were getting pension when he was alive. What are you submitting?
How is that possible, my lord?
Therefore, how you are submitting they were not dependent?
They are having a separate income. They are having a
Now they are getting the pension after he has retired or after he has died. That is because they were dependent on him. Otherwise, they would not get the pension. How can you say they are not dependent? A unique submission is being made. Therefore, we are asking you. They are not dependent. Not dependent means dependent on whom?
the deceased employee.
So they were dependent. Otherwise, they would not get the pension.
It's a,
How they will get the pension if they are not dependents?
it's a natural corollary. They would receive the family pension.
Only dependents will receive, dependent family member.
That's a natural one, my lord.
So therefore, we don't know how you are making such submission. That's why we are failing to understand. Either we are unable to appreciate what you are trying to say or you are unable to convey. Whenever you use the word they are not dependent, dependent on whom? And what is the test to see dependency? Whether they were dependent on the government employee or not. And who is a dependent is defined at
That
the
is
beginning.
that is in the scheme itself. That
So both
Yeah.
married and unmarried daughter and wife, all three are.
Then everybody.
So
comes
how
under
you are
the
saying
umbrella.
not dependent, we don't know. Therefore, we are trying to understand.
Fine. I've got your lordship.
Yes,
Therefore, my lord, everybody who is before your lordship, then
they are
everybody
all
is a-
dependents.
dependents.
Therefore, at the outset, we observed that NOC is required from all three for employment in favor of anyone.
Anyone.
Anyone. Therefore, either it is impossible or you can make it possible.
Lord, I have conveyed it to my.
Anyway, so they are not dependent. And what is your next submission?
তো বলে দিচ্ছি। ঠিক আছে নেই তো ঠিক করে দেখে নিন। But these are the points, my lord, which I was
So not the first is that mother is not is overage. She is not herself capable. Second is the daughter has not come.
Daughter has
Not come.
come before you.
She is the married daughter. She has not
She has
come
not taken a
challenging the
separate-
daughter. She has not. And third is that they are not dependents.
They are not dependent, having separate income.
Having pension, taking pensionary benefits. There is no other income referred by you
Well,
in the tribunal.
I am not aware of anything else.
No, because the tribunal, it is
Yes,
recorded, only
because-
pension. Yes,
I am not supposed to know anything more about the income, my lord.
getting pension.
And my lord, the applicant is an unemployed, unmarried. She is also entitled and eligible. To
All three are eligible, yes.
But all three or all two? If she is age barred, mother.
She is eligible for the benefits. She is the first person entitled to the benefits. All of you are secondary, both of you.
But she's 60 years old, my lord. How can she get?
Therefore, all the more she needs the benefit.
Yes, yes, yes.
She is the primary person requiring the benefit. Yes.
Because of, or my lord, leaving aside all other things.
Everything else aside. Yes.
Everything else, because mother is the primary
Beneficiary of the
I
scheme,
bow down to your
whether
lordship.
through you, through her, or directly. That's all.
And I have got nothing more to.
Yes. No, but you see, what we are observing, it cannot be avoided by any of you.
I cannot add anything or change your lordship mind.
Ultimately, in this quarrel, the situation will remain that none of you will get the appointment.
It will become a dead topic.
A little more time, but you were not.
No, but what can he do if he is not getting this? Therefore, it was upon, we observed, we made an observation that parties may not understand, lawyers will understand. If a lawyer understands, it is for him to advise the client that look, you will remain fighting for your life and you will never get it. And that is because if they know that ultimately they cannot succeed, then they may agree to resolve the issue. If they think that they will succeed, then they will never resolve the issue. But they may think it will remain elusive, that is for sure. Neither your client will get it, nor their client will get it. And they are getting the pension, you are getting nothing. As of today, whatever if you are saying is correct, and if they are not giving you anything, you are getting nothing.
I'm getting nothing.
You may continue in this circle. This is a fit case for a mediation settlement. Because none of the parties can win this litigation. That is for sure. In this stalemate, none of the parties can.
It's a stalemate.
More interested in a victory. No, it appears that he is more interested in a victory in this case. A fruitless victory you want, you may have it. We are here to give it to you.
No, initially I said,
yes,
you take a last chance, you try.
Get nothing.
Your lordship may kindly send this to the mediation if your lordship so.
We think that it is the best thing to do.
Lord, we have got no objection if it is being sent
All
to the.
three of you.
On instructions, I am saying. When my instructing advocate is here, my lord. On instructions, right?
An issue arising for consideration
But this would have been the best possible course which you have fallen from your lordships.
Otherwise, it will not be, nobody will get it.
Or not.
You have to impress upon your clients. If they see reason, they do, otherwise.
Obliged, my lord. 8-4. Come to me.
Very few classic examples for mediation. This is one such. Very few times we get a classic example for mediation. There is no option but to go for mediation.
In the morning also, my lord, the similar order has been passed by your lordships in the morning.
Yes.
That is regarding the two wives. The
Can be done. Solution because both should sustain. Our prime consideration is that all should sustain. Now he has contracted a second marriage or solemnized, how is that relevant? If there is no dispute that he has solemnized the marriage, where is the children's fault? They have to sustain.
my lord, we have understood that. Obliged, my lord. Reach.
17.
When there is no fault of second wife also.
Knowing if she's lying regarding the first marriage, then she has taken a risk. His millions of law can presume that she knows.
Yes, any feedback on this query?
But, so far this matter is concerned, Lordship, kindly, my lord, recollect that pursuant to my lord's order, with regard to my lord, the earlier.
Have you seen our last order?
Depending all, my lord, the area that has been paid.
No, sir, please. Hey, show him.
The
issue is whether he could have been transferred to another district or not. We wanted to know whether it is cadre is district cadre or a state cadre. Because otherwise that provision which is being relied upon, how we can harmonize if it is a state cadre,
Yes.
then how you can say that he must be posted close to his home? So we wanted to be clear whether it is a state cadre or a district cadre.
Yes, yes.
That is the query we have made.
Then, my lord, kindly, my lord, take it any other day, my lord, I shall see kindly.
Mr. Bhattacharya has been waiting for this. We
Sorry.
could have talked to each other.
And next week. Next week.
We
The
think
order
that is
to-
relevant. We should know before we pass the order.
Might.
Otherwise, the scheme or provision will have to be read in the context.
Because whatever, my lord, sorry, whatever, my lord.
You are still at that place.
Yes.
Yes. Heard the
On the
learned.
next day, my lord, only, my lord, I shall rely upon one judgment that, my lord, that the memo or, my lord, geo, what, my lord, they are relying upon. The memo or geo they are relying upon that in case of group D staff, the transfer should be as far as possible within the home, I think, so that he can reach to the within a reasonable distance. Now, my lord, there is a judgment that this type of, my lord, the geo or memo, these
Are only guidelines.
Guidelines.
They have no binding force.
Yes, binding force.
We will take that judgment into consideration. We don't know what we'll do, but we'll take
But
that.
my
And
lord-
we have seen that judgment in other cases.
My lord.
And relying on that, we have rejected so many cases. But in a group D employee,
Yes, my lord.
we find it.
Let me-
We'll see what can be done.
My এই অর্ডারটা দাও তোমাকে
We'll see that.
নেক্সট উইকে যে কোনো আপনি বলুন মানডে ছাড়া মানডেটা
See, if there is no pressing urgency for you, then coming 2 weeks, there is some uncertainty on this side. So we'll have to keep it in March, second week.
মার্চ ফার্স্ট উইক my lord, I may not be
Second week, sir.
Second.
You have already said once that you are not available. This from
হ্যাঁ
16th March, the stock is learned, the AG submits that in the meantime, we will take instructions with reference to the last order dated 2/2/2026.
একদম মাথা থেকে বেরিয়ে গেছে।
My lord, I appeal for the petitioner. My lord, your lordship may recall this matter where the petitioner was proceeded by the government and State Vigilance Commission was given the inquiry part. My lord, the inquiring officer, after holding, my lord, found that no documents were supplied. My lord, dropped the inquiry proceeding. And my lord, thereafter, without any other thing, my lord, although my promotions were due at that point of time, I was neither granted the promotion. One fine morning, my lord, I received a further notification appointing a fresh new inquiring officer to inquire into the charges. My lord, this is the issue, my lord. At 24/9/2024, my lord, your lordship kindly have a look. But 24th of September order, if your lordship kindly take notes, my lord.
There are two things. One is that he was to satisfy himself.
Yes, ma'am.
The other is the provision regarding Vigilance Commission.
Absolutely, ma'am.
Two things were required.
What fell from your lordship on the last occasion, that after going through that page 68, that the inquiring authority said that drop the proceeding. Now, my lord, the question arose that whether inquiring authority can drop the proceeding, can say that everything concluded, there is no more. Now, my lord, before that, my lord, the leave was granted to me to take instruction that why the required papers were not provided with to the concerned the inquiring authority. That means that what culminated to pass this order. Now, my lord, after obtaining instruction, now, my lord, I have handed over a short list of dates. If your lordship kindly have a look, there, my lord, we have stated that under what circumstances the papers were not provided with. দিন না, দেখে দিন না, এরকম লিস্ট অফ ডেটস আছে। এরকম লিস্ট অফ ডেটস আছে, এই যেরকম দেখাচ্ছি আপনাকে। না না, আলাদা করে, মানে ডিউরিং পেন্ডেন্সি, ডিউরিং প্রসিডিং, এটাই তো দেখি। ইয়েস, দেখি, দিস ইজ লিস্ট অফ ডেটস। ইয়েস, এটা আরেকটা আছে, দেখুন। না, my lord, everything is reflected herein. If your lordship kindly have a look, my lord, the 19 July 21, that was the date the Special Secretary State Vigilance Commission West Bengal, in writing of event date, mooted a proposal and or expressed its opinion that there are materials for proceeding against the writ petitioner departmentally under WBS CCA rules. Then 4th April 2022, by memo number such and such event date, the petitioner was served with articles of charges along with an intimation that an inquiry would be held under Rule 10 of that service rules. Then, Lordship, kindly come to 24th August 2022. The additional principal chief conservator of forest and chief conservator of forest, the personal management cell, West Bengal, by memo number such and such of event date informed, that is the his principal employer, informed the deputy secretary to the government of West Bengal Department of Forest that the departmental proceedings after having been initiated against the petitioner, a formal request had been made to the State Vigilance Commission West Bengal to hand over all relevant reports, documents and records in respect of which the charges were framed. The letter further contained that till the date the required documents were not supplied to the office of the chief conservator of forest, who will provide to the minor inquiring authority. Then November 13, 2024, by memo number such and such of event date, the additional principal chief conservator of forest, human resource development West Bengal, requested the Commissioner for Departmental Inquiry and IA, State Vigilance Commission, to hand over to the petitioner the documents referred to the Annexure 3 of Articles of Charges. Then December 13, 2024, the Inquiring Authority, being Commissioner for Departmental Inquiry and IA, State Vigilance Commission West Bengal, passed an order of event date as communicated with a forwarding letter to the additional principal chief conservator that in view of failure of the department of principal chief conservator of forest to supply the relevant documents to the charged officer, despite the fact that all these documents had been provided to the said department by the State Vigilance Commission, the said departmental proceeding. That means inquiring authority thought that everything after having been provided, still it was not forwarded to the inquiring authority, where the fact was not such. Then July 2, 2025, the Deputy Secretary State Vigilance Commission, even date forwarded, now forwarded, after that order passed by the inquiring authority, forwarded the copy of documents as mentioned in Annexure 3 of Articles of Charges in connection with said departmental proceeding to the additional principal chief conservator. Now, my lord, my lord, came to our hand. Then July 14, 2025, by order of event date, then fresh inquiring authority was appointed in place and state of earlier one. And my lord, then they have, my lord, and then yes, July 17, additional principal chief conservator by memo number such and such forwarded all the documents including annexure to the charges to the present inquiring officer as well as to the read petitioner. Now he filed that, my lord, the way that based on this, my lord, the order passed by the inquiring authority, assuming that despite having been the fact that we got all the departments, I think the noting and, my lord, the relevant papers, we did not provide it. But after that order, my lord, we received the same. And then it was forwarded to the, my lord, the present inquiring authority as well as to the, my lord, the read petitioner. All the, my lord, the whatever, my lord, the documents, my lord, the relied upon in support of the charges, everything provided with. So, first of all, the fact was not what, my lord, he said that this was the fact, that was not the fact. If your lordship kindly come to, my lord, page 68. Page 68 is the foundation of their, my lord, the claim that after that nothing could be proceeded with. Page 68 is that, my lord, the order of the then inquiring authority. And the inquiring authority said, in spite of supply of all the documents by the State Vigilance Commission.
Is it your submission that the disciplinary authority did not have the documents?
Inquiry disciplinary authority did not have the documents at that point of time when the vigilance, my lord, vigilance recommended for that, and on the basis of the report of the vigilance, my lord, it was started. And after that, my lord, we repeatedly sought for the
so therefore
all the documents.
If what you are saying is to be accepted, Then that means the disciplinary authority's framing of the charge memo is only on the recommendation of the vigilance.
It appears from the record.
So
It
therefore,
appears-
then arises the next question that we asked.
Yes.
What is the scope of this commission? Show us that it, once it gives a recommendation,
No.
there is no discretion in the disciplinary authority and that he has to frame the charge memo, whether there is any
Here-
material before him or not.
Here, my lord, may I take the exception to this, my
So
lord?
there are two things. One is, which we have understood, you are saying it was not with him, how he could have given.
Yes.
So this factual basis is
And there are, my
unsustainable.
lord, the correspondences, my lord, exchange between the, my lord, the vigilance and the disciplinary proceeding, that please supply us.
Correct. So that
we
is
can also
you are
forward.
referring here.
Yes. we
That
can
has
also
not been
forward.
considered. Therefore, this factual error is there.
Now the question is.
Therefore, from that stems the other issue. That if this is the crux of the issue, then after all, how he framed the charge memo, if he did not have, then he must have framed it only on the recommendation of the Vigilance Commission.
Yes.
So what is the nature of this recommendation? It has a binding effect. It has to be followed blindly without looking at any material. Therefore, we asked you that show us two things. One is the first question which you have just shown. Second is what is the scope and jurisdiction of this commission and how its orders are to be treated by the disciplinary authority.
So far the, my lord, so far the authority of the inquiring authority itself is concerned. My lord, my humble submission first thing is that the inquiring authority cannot conclude the proceeding in this way. My lord, the inquiring authority can conclude the proceeding in either way, that the department has failed to prove the charges, or he can come to a conclusion that the department has proved the charges, either all the charges or some of the charges. But the inquiring authority cannot say that because of such and such fact. Thus, kindly consider, my lord, the language. He cannot, my lord, come to a conclusion in this way. I am coming to that, my lord, and I shall rely upon a judgment also. That should kindly come to.
Yes.
Now, my lord, kindly come to that page 68.
We are looking at
Yes,
it.
Lordship. My lord, kindly look into my paragraph 1, 2, 3. Lordship, kindly, my lord, paragraph 3. It seems that the concerned department is not interested to start departmental proceedings against the charge officer, and thus making mockery of justice by not supplying the relevant papers and documents to the charged officer, and also wasting the valuable time of this forum. Be it mentioned here that the disciplinary authority was supplied. Now, the main, my lord, this was not the fact. Be it mentioned here that the disciplinary authority was supplied all relevant papers by the Office of State Vigilance Commission by memo number such and such on 19th April 2021, which was duly received by the concerned department. First of all, that was not correct. Then, my lord, in the aforesaid premises, it transpires that in spite of supply of all the documents by the State Vigilance Commission to the Department of the Office of Principal Chief Conservator of Forest, Aranya Bhavan, Salt Lake, the department has failed and neglected to comply the order of the undersigned. As such, the Additional Chief Conservator of Forest, Human Resources and Development, West Bengal, is directed to draw up proceeding against arraigned officers who have failed to comply the order of the undersigned. Then the next. Since non-supply relevant documents to the charge officer curtail his right of natural justice, and also the charged officer is suffering with mental harassment since the inception of the departmental proceedings against him, considering the above facts, the undersigned is of the opinion that it is relevant
irrelevant to continue with the proceedings in spite of reminders to the concerned department of supply of relevant papers to the charge officer. Hence, it is ordered that the instant proceeding against the charge officer is dropped due to non-supply relevant papers to the charge officer. Now, my contention is that my lord, for non-supply of relevant documents to the charged officer or to the, my lord, the inquiring officer, but the inquiring officer cannot come to this conclusion that you are not interested and so the entire proceeding is dropped. Now, my lord, on that score, my lord, I just rely upon, my lord, the one judgment of Honorable Supreme Court, my lord, reported in 1998, 7 SCC, my lord, page 84. Our copy kothay gelo?
Punjab National Bank. Punjab National Bank Coachbihar.
এটা তো দেবেন তো জোশে।
No, sir. No, sir.
My lord, kindly, my lord, have a look at paragraph 18. Straightway, my lord, may come to paragraph 18.
Kunji Bihari, Mr. Judge.
Kunj Bihari, Mr. My lord.
Yes.
In case of de novo, what is required to be done?
My lord, paragraph 18 is very important. Lordship, kindly.
Reasons for differing with the inquiry.
Absolutely, my lord.
I'm coming.
Then opportunities.
Yes, yes. No, there are maybe other things.
My lord, the ratio decidendi, what it says, under regulation 6, the inquiry proceedings can be conducted either by an inquiring officer or by the disciplinary authority itself. When the inquiry is conducted by the inquiry officer, his report is not final or conclusive, and the disciplinary proceedings do not stand concluded. Now, my lord, very important this expression, and the disciplinary proceedings do not stand concluded. The disciplinary proceedings stand concluded with the decision of the disciplinary authority. I am on this. The disciplinary proceedings stand concluded with the decision of the disciplinary authority. It is the disciplinary authority which can impose the penalty and not the inquiring officer. Where the disciplinary authority itself holds an inquiry, an opportunity of hearing has to be granted by him. That is the separate issue. When the disciplinary authority differs with the view of the inquiring officer and proposes to come to a different conclusion, there is no reason as to why an opportunity of hearing should not be granted. It will be most unfair and iniquitous. Now, there might have been the issue was that whether, my lord, the second show cause or another opportunity should be given by the disciplinary authority when in case of any difference of opinion or views with the inquiring authority and the disciplinary authority. My lord, it's a settled law. I am not on that. But, my lord, the Supreme Court says that the inquiring authority cannot be the final say, neither with regard to imposition of fine, penalty, or, my lord, the punishment, neither with regard to, lordship, the conclusion of the inquiry proceeding, that the disciplinary authority is the final.
Correct.
Whether concluded or not.
This is settled law.
Settled law. Now here
proceeding ends with order of the disciplinary authority.
Yes. Yes. Now here, my lord, the proceeding.
So after the inquiry officer's report here, did the disciplinary authority differ with this finding?
Here, my lord, there is no finding.
So
by simple submission, here there is no finding. Here there is no finding can only be by the inquiring authority. Lordship, kindly consider that the charges leveled or slapped upon the, my lord, the charge officer, that, my lord, the department or the my lord, they fail to prove.
That's all right.
They or the charges or one of the or some of the charges have been proved. If the charges fail to prove, then naturally, my lord, the conclusion is that, my lord, that yes, the opinion and the recommendation and that yes, charges failed. Now again here, the disciplinary authority can take an exception. That I do not agree with you.
That's why we are asking, what has he done? Has he done anything? That
Well,
we do, I do not agree that it is a case for dropping the.
That is why the second inquiring officer has been
Where is the order
appointed.
passed on this report?
The second inquiring officer was appointed, and at this juncture, my lord, the way has been filed.
So where is that order?
Yes.
Page 70.
70, my lord, 70, 70. And it starts with as recommended.
So therefore, whether this course is available to the disciplinary authority, that is all we are asking. Whether it is open under the WBSR to order a de novo inquiry after submission of an inquiry report, or an order is required to be passed by the disciplinary authority that the inquiry officer's report is not acceptable. He has not looked into things. He is required to further see the things, or I am in disagreement, or I agree. Is there any scope beyond these three options under the WBSR?
Now, my lord, if your lordship, my lord, kindly come to my lord, Rule 10.
Yes. WBSR Rule 10.
My lord, Rule 10, yes, my lord, the 71 rule.
Yes.
WBSR 71 rule, Rule 10. Have you got it, my lord?
Rule 10?
Yes. Where, my lord? 71 rule.
TCA rules, my lord.
Yes.
Classification control appeal rules.
71.
71. West Bengal Service, yes, classification control rule 71. Have a look. Copy আছে আর? এই copy আছে?
না স্যার আমি মোবাইলে দেখছি হ্যাঁ সিসি রুল স্যার
আমি জানি মাইনরের কাছে আছে। দেখুন না। থাকা তো উচিত। CS rule 71 থাকছে।
71 is regarding subsistence grant violence.
West Bengal Service classification control, that is the, my lord, the main, my lord, the rule with regard to that, my lord, the conduct of inquiry appointment.
I do have the tab, my lord, if you lordship.
This is central government. We want to see West Bengal. Is it available in this?
Most likely no, man. No, it's not available. It's WBS, it's not available.
It is available. This is in the book.
আমার কাছে
West Bengal Service Rules CCS we have got one day from the
ওই আমাকে জেরক্স করে রাখতে এরা কিছু পড়ে ঠিক এখানে তুমি আমাকে ওইটা দিয়ে পড়ো আমি মাইলটকে দিতে দেবো
My junior do have the
না না তুমি আমাকে এটা দাও
বই আছে স্যার আমার এই লর্ডশিপ গ্রান্টস মি 1 সেকেন্ড টাইম আমার ওর কাছে বই আছে বাইরে
এই বলি না জেরক্স
হ্যাঁ স্যার আমি তো আছে
আমি তোমার থেকে পড়েছি
বই এনে নিচ্ছে স্যার
কিন্তু এই বইটা তো লাগবে এখানে না না এখানে my lord this book is very much important for service matter.
Dispensable while here.
There are two books, my lord. One is, my lord, with regard to DSR.
Service rules.
There are one Pashupati Ghosh books with regard to DCRB and my one Pashupati Ghosh book with regard to my lord the CCA rules, probation rules, all the rules are there. Pecho. This compendium is there, my lord. This is rule 10, my lord. Page 66. এই বইটা পাবেন না, এখন পাওয়া যায় না।
I'm sorry, my lord. May I just read out and hand it over, lordship?
ঠিক আছে, লিখে গেল। সবকিছুই কাজে লাগে, কোনো কিছুই ফেলার না। এখানে কি বলা আছে? ডিসিপ্লি গুলি কি বলছে লেখা নেই।
My lord, may I read out, lord?
দেখে মনে পড়ছে না।
My lord, the rule 10, my lord, this caption is procedure for imposing penalties. Now, my lord, no order imposing any of the penalty specified on Rule 8 shall be made except after an inquiry held in the manner provided in this rule. Then the disciplinary authority shall draw up or cause to be drawn up substance of the imputations of misconduct or misbehavior into definite and distinct articles of charges. Then a statement of imputations of misconduct or misbehavior in support of each article of charges, which shall contain a statement of relevant facts, including any admission or confession, and a list of documents by which and a list of witnesses by who the articles of charge are proposed to be sustained. Then the disciplinary authority shall deliver or cause to be delivered to the government employee a copy of articles of charge and the statement of imputations of misconduct or misbehavior prepared under clause 2 of subrule 2 and shall require the government employee to submit to the inquiring officer within such time as may be specified a written statement of his defense and to state whether he desires to be heard in person. My lord, may I pause here for a moment? My lord, subrule 1-2 that has been, my lord, complied with. Then the disciplinary authority shall in all cases for the purpose of inquiring appoint an inquiring authority and forward to it a copy of the articles of charges and the statement of imputations of misconduct or misbehavior, a copy of statement of witnesses, if any, evidence proving the delivery of the documents referred to in subrule 2 to the government employee. So evidence proving the delivery of documents, that is, my lord, the imputation of charges that has been proved that yes, that was, my lord, the served.
Not
Now
documents, only charges.
only charges, yes. Evidence proving the delivery, no, only charges.
Only charges.
Only charges.
No list of documents, no list of witnesses, no documents, nothing.
Yes, articles of charges and statement of imputations of misconduct, that is 4A complied with. 4A.
Compendium.
No, statement is there.
A copy of the articles of charges and statement of imputations were served.
Maybe. Even
Yes,
if
served. Now, lordship, kindly come to 5.1. The government employee shall appear in person before the inquiring authority or such day, such time within 10 working days. Lordship, may I, my lord, skip it? Then government employees to department of person have been instrumented. Then, my lord, kindly come to
ঘোষাল, তাই তো? ঘোষাল।
my lord, come to my lord. It starts practically from subrule 6. If the government employee who has not admitted any of the articles of charge in his written statement of defense appears before the inquiring authority, such authority shall ask him whether he is guilty or has any defense to make, and if he pleads guilty to any of the articles of charge, the inquiring authority shall record the plea, sign the record, and obtain the signature of the government employee thereon. The inquiring authority shall return a finding to guilt in respect of those articles of charge to which the government employee pleads guilty. the inquiring authority shall, if the government employee fails to appear within the specified time or refuses or omits to plead or claim to be tried, require the disciplinary authority of the or his representative to produce the evidence by which he proposes to prove the articles of charge, and shall adjourn the case to a later date not exceeding 30 days after recording an order that the government employee may, for purpose of preparing his defense. Now the question: inspect within 5 days of the order or within such further time not exceeding 5 days as the inquiring authority may allow the documents specified in the list. Now the question of documents, my lord, comes in the proceeding with regard to, my lord, the inspection of document that I may be relied upon to prove the charges. Now the question of documents come. At this stage of inquiry, not at the threshold, at this stage of inquiry, first inquiring authority, my lord, authority fix a date, he will appear. He may, my lord, plead the guilty, may not. If not, then, my lord, the next date, the inquiring authority, my lord, before whom, my lord, the department shall, my lord, place the documents, and he will ask to inspect the documents. At this stage, my lord, now he starts that the documents are available or not to prove the charges. Inspection, then submit a list of witnesses, then give a notice within 10 days of the order or within such further time not exceeding 10 days, may allow asking for discovery or production of any document, just like a suit, for discovery or production of any document which are in the possession of the government, but not mentioned in last mention. Then the inquiring authority shall, on receipt of the notice for the discovery or production of document, forward the same or copies thereof to the authority in whose custody or possession the documents are kept, with a requisition for the production of the document by such date as may be specified in such requisition, provided that the inquiring authority may, for reasons to be recorded in writing, refuse to requisition. Here, suppose, my lord, may I pause here for a moment? Here, suppose, my lord, the letter of the inquiring authority to the, my lord, the disciplinary authority is, my lord, in terms of this, that the requisition for supply of documents. Then, my lord, if, my lord, fail to, then what happened?
Yes.
So, up to then, my lord, we now, my lord, come to, my lord, sub-rule 7, that production and inspection, production of document and inspection by the charge officer. Then 8, on receipt of the requisition referred to in sub-rule 7, every authority having the custody or possession of the requisition document shall produce the same before the inquiring authority. May I clear, lordship, kindly. Now rule 8, after rule 7, requisition, now sub-rule 8. Yes. Sub-rule 8 is very clear. On receipt of the requisition referred to in sub-rule 7, requisition by the inquiring authority, every authority having the custody, my lord, this is very important. Every authority having the custody or possession of the requisition document shall produce the same before the inquiring authority. On that day, my lord, it was not in our custody, my lord, we have stated it. After that order passed by the inquiring authority, dropping that everything, then, my lord, we got it. Provided that if the authority having the custody or possession of the requisition document is satisfied for reasons to be recorded by it in writing that the production of all or any of such documents would be against public interest or security of the state, it shall inform the inquiring authority. Well, it does not apply here. Then, 9, after the completion of the inquiry, a report shall be prepared and it shall contain, I am on this. What should be in the report? My lord, lordship, kindly, this is, my lord, the periphery of his, my lord, the authority. Lordship, kindly come to, my lord, sub-rule 9.
Yes.
Sub-rule 9 speaks, after the completion of the inquiry, a report shall be prepared and it shall contain the articles of charge and the statement or imputations of misconduct or misbehavior, the defense of the government employee in respect of each article of charge, an assessment of the evidence, in respect of each article, the finding on each article of charge. Then the disciplinary authority shall consider the record of the inquiry and record its findings. If the disciplinary authority, having regard to its findings on the charges, is of opinion that any of the penalties specified in clause Roman 1 to Roman 3 of Rule 8 should be imposed, it shall pass appropriate order. And then if the disciplinary authority, having regard to its findings on the charge, is of opinion any of the penalties specified in clause such and such should be imposed, where the commission recommends in any of the cases. So and then, my lord, the sub rule 16, the order passed by the disciplinary authority, then only, my lord, it comes to the, my lord, the end of the disciplinary proceeding.
You need not impress. This is a settled law. Proceeding commences from the date of submission of charge memo and ends with the order of the disciplinary authority. That's not the issue here. The issue is whether inquiry officer can proceed on the basis of a charge memo without supporting documents, and whether he can be compelled to participate in such a proceeding. If the inquiry officer has given a report that due to such lapse, I drop the proceeding, what is the consequence? It is for the disciplinary authority to invoke his jurisdiction to pass an order on the inquiry officer's report, or to say that somebody else is appointed, now he will carry on. What he will carry on when it is dropped?
For my humble submission that the whatever the order passed in this proceeding at page number, my lord, 68, well, that is nothing but a recommendation. Because he cannot conclude the inquiry authority's recommendation.
Even if we accept that,
yes,
that recommendation has been dealt with by which order? Whether that recommendation has been rejected or that recommendation has been accepted by the disciplinary authority. If so, by which order? We accept what you are saying, that it is a recommendation. Now, what the disciplinary authority has decided on this?
No, my lord,
where is the decision?
My lord, it appears from page number 70.
Please read what it says. Nothing on this. We have gone through it. That's why we are asking you. It does not say anything. It says now you go and inquire. What he will inquire when it is dropped? When he is not saying that I don't accept this finding. It needs to be inquired. You go and inquire. He is not saying anything. He's saying, oh, he has, now you go and inquire. Inquire into what? He is required to say that that order is not sustainable. Those charges are very much alive. Go and give the documents, proceed further. You please read page 70. It says nothing about the recommendation which you call. It says now instead of his place, you go and do it. What he will do?
May I tell, Lordship?
Please read page 70.
By, my lord, may I tell, my lord? By
please read page 70 what it says.
Yes. It starts as recommended by the State Vigilance Commission, by Deputy Secretary State Vigilance Commission, dated 12th June 2025. That means, my lord, after that, my lord, that was.
And in cancellation of office order dated 15/7/24.
Yes.
What is 15/7/24?
My lord, 15/7/24, possibly, my lord, that was the, my lord, the letter of appointment to the.
That must have been appointing the inquiry officer. So now if the inquiry officer's report is not to your liking.
Lordship, kindly come to 15/7/24 is at page number 64.
Correct.
That is the appointment of the.
So therefore we are saying, if his report is not to your liking, you will say in place of his place, now you go and inquire. Where is this option under Rule 10? You are referring to Rule 10. We'll consider this. You also have a look at it from that point of view. Yes, for further consideration, matter is adjourned.
get